love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And Just to Serve TV is on the air. Hey, can we hire somebody just to fan me while I'm sitting here? Is that?
Yeah, it's the funniest thing. When I thought you were coming, I would have bought it as a prop. I bought my, how Bob Bianchi and I, still from Long Crime, have those little tiny fans that we have, and I actually had packed it in my bag because initially there was a thought that I would come up and do the show with you from outside, and then we decided no, we've got too much going on and all sorts of stuff, and now I'm here. We may have a little change of plans, right?
Yeah, so let's set up where we are, what we are, and what's going on here. Obviously, that's Linda Kenny Bodden. I'm Michael Bryant. I'm here in Dedham as we wait for the Aiden Carney hearing, discovery hearing. We think motion to dismiss, probably not, but that's going to happen. It's penciled in for 2. We're hearing that attorney Tim Dreidel is running late. He's Dreidel. He's a little Dreidel's a whole different thing. Dreidel, he's a little bit out of town.
I was going to say that you're getting you sound a little confused,
and I'm not even Jewish.
And maybe you've been watching about. You wouldn't be confused because of that, but because maybe you've been watching a trial this morning that's very confusing.
Okay, let me set this up before we transition into that. Okay,
I know. Just everything happens.
So we're here to cover that, and we will. But because of Mr. Breidel's out of town obligation, it may not be till 2:30ish. We don't know. At 2ish, I'm going to get into the courthouse. So that's all set and done. And before we shift gears into COSOTUS, as we've all been talking about, as we were last night, we had Kim, not Williams, on.
Cat, not Williams.
Cat, because it's been an amazing case with a few wrinkles. Today, some wrinkles as well in this case, because last night, it seemed to me it was at 10 or 10:30, Commonwealth dumped 4,000 plus pages of discovery on Aiden Carney's team. This is stuff that's been asked for, fought over for months. But now we're going to hear Special Prosecutor Cosgrove say, "Hey, Judge, I've turned everything over. It's all. Well, what I'm hoping, and we see this in the Walsh case, the others that are related to that in terms of the discovery and the federal investigation, the judges have been wimps and not holding the Commonwealth to their requirements. This is the perfect opportunity to do that. Yeah, Mr. Cosgrove, you turned things over last night, just before midnight. What the hell is the deal?"
Oh, let's see. Those are the pages that were blank last time.
Yeah.
Oops. Yeah, but does it help?
Oopsie. Yeah, because the first drive had about the same number of pages and virtually all were redacted, totally black. It's bullshit. It's game playing. And the reason it happens, the reason it continues is because the court will not put these folks in their place and make them follow the law. So we'll see.
And you know what I say, Michael? You know what I say? For every wrongful conviction that there's been in this country, and there's been a lot of them, there's been a judge sitting on that bench. And the judge should have been taking off the robes and sitting at the prosecutor's table, because unless they hold them accountable, that's exactly what they're doing. They're prosecutors.
Yep. So it's another opportunity. I'm going to be a Pollyanna about this. It's another opportunity for the court to do the right thing and find some sort of sanction for this delayed discovery production. We'll see. We'll find out. That's what's going to happen in this courtroom.
All right. So you're going to leave us. You're going to leave us about 1:45 so that you can get in about 2. By then, we should know about when the hearing would begin. It was supposed to begin at 2. Some are saying 2:30, 2:45, maybe even as late as 3 o'clock. We do have the Zoom link into the court, though. I don't know if it's going to be audio or video, but if it's audio, I assume there'll be a camera in there taping it like last time, like 25 was, and releasing it, tomorrow. But we'll be there, and then when you come out, we'll talk about it, and you're going to interview. You've already seen some of our old friends, Scott's up there, right?
Yes. It's the band is getting back together. I've seen a number of folks who are supporting Aiden as they did Karen Reed, because of the incestuous nature of all of these cases here in Norfolk County. So not just Norfolk County is odd. Let's go to Liberty County. We've been talking with Doug Weinstein. He's the attorney for the defendant, Nicholas COSOTUS, in the case. This is the defendant accused of murdering and dismembering his wife. He has got a story to tell. We have Cat Not Williams feed up, and we're going to jump into that.
All right, guys. So if you missed this morning, this is cross-examination of the defendant that we're about to get into.
He's taking the stand. The reason why I'm wearing orange Okay, it's because last night Dougie had a chance.
Maybe we'll actually, I'll remember that we're doing
crazy. And now, I'm glad Doug is probably happy sitting down and cross-examination. Yeah. Here we going to
go.
For
those who don't remember, during our show last night, Doug chatted in. He texted no witnesses. So we know there is a client control issue of mammoth proportions here when we see Casotis on the stand. Basically, might as well put a gun to his head. Whatever chance he had is now over because the guy is a colossal bullshitter.
Everyone, please be
Not only that, we saw last night, Doug ended on it. You don't have a murder weapon.
Oh, it was perfect.
You don't have bliss. You don't have that. It was perfect.
Thank you, Your Honor.
And then he had to go over to see his client who had him ask some stupid questions, right? That means the client had control. So here we go. Let's see a little bit of crazy under cross-examination.
This is a cross-examination you dream about.
Good afternoon, sir.
And thank you, Queen Olive, for joining us, new member, for this. Thank you very, very much for joining us. Thank you.
Mr. Casotis, or Mr. Stark, you
Great
indicated that you were
already a dig
officer in the Judge Advocate General Court, correct?
Yes, I was.
And you were in that capacity for over 10 years, right?
Roughly 10 years.
You went to Boston University College.
Yes, I did.
You went to Northeastern Law for your JD.
Yes, I did.
And then you got your LLM in cybersecurity from Georgetown, correct?
It was in national security with a emphasis in cybersecurity.
Okay. All prestigious schools, right?
Yes.
You did very well in school, correct?
Yes, ma'am.
And as a JAG officer, you indicated that you were both a defense attorney and a prosecutor during your term as an officer in the JAG?
Yes, ma'am.
Be fair to say that the Navy requires JAG officers to be very on top of your cases, right?
Absolutely.
To be careful with records, correct?
Correct.
To be careful with what you send to whom, correct?
Absolutely.
You check and double check pretty much everything, right?
Sometimes many more checks than that.
You never looked at Jim McIntyre's credentials, right?
Correct.
Now, I just want to start with some of the things that we have in evidence. I'm showing you 2.26C. This is the photograph from Home Depot. That's you, right?
Yes, ma'am.
And that receipt that's attached to that from November 29th of 2022, that's also you, right?
Yes, ma'am.
Says your name on the receipt, correct?
I believe it does, yes.
It also says that you bought the Milwaukee Smooth Blade insulation knife on November 29th of 2022 at 8:56 a.m., correct?
Yes, ma'am.
And you saw the testimony from Special Agent Bernie with the FBI, correct?
Yes, ma'am, I did.
And that showed that your vehicle, your phone, and your business record put you in the vicinity of that Home Depot, correct?
Yes, ma'am.
You don't dispute that, do you?
No, ma'am.
And in fact, you then watched as he showed all of the different waypoints of your vehicle traveling down towards Riceboro, correct?
Yes, ma'am.
You don't dispute that that was your car, right?
No, ma'am.
You don't dispute that that was your phone, right?
No, ma'am.
And you don't dispute that that was you in the vehicle at the time.
That is correct, ma'am.
Okay. You saw the records introduced concerning the 2022 Ford Explorer purchased from J.C. Lewis, correct?
Correct.
And I'm pointing to 1.19. Do you recall seeing those business records introduced here in court?
Yes, ma'am.
And you don't dispute that you bought that car, correct?
I do not dispute that.
You don't dispute you paid cash for it?
It was a check, but yeah.
It was the full amount.
Conversationally, yeah, you paying cash rather than financing. Yes, ma'am.
Okay. And you bought that car under your own name, correct?
Yes.
And that purchase was
I believe it was July 27th of 2022.
right, correct?
Yes.
Okay. And when you bought that vehicle, that did not have a police intercept package on that vehicle, correct?
I don't believe so. I'm not sure what a police intercept package is, though.
Right. Because if it did, you would have paid extra for options, right?
Right. I mean, there were options on there that I did pay extra for. I assume that anything else would have been also additional.
Now, you also purchased $2.25C. Not this specific kit, but one that looked just like it, correct?
I believe so, ma'am.
This was a 7-piece deer processing kit, correct?
That's what it says, ma'am.
Well, you saw the business record from Bass Pro, correct?
Yes, ma'am.
And they indicated that you purchased that item. Is that right?
Yes, ma'am.
You don't dispute that you did, correct?
No, ma'am.
He
And
just said he
it's
bought
your
it from
testimony
Mindy.
in court here today that you are not a hunter, correct?
That is correct.
You were not going hunting on November 29th of 2022, correct?
No, ma'am, I was not.
And just so we're clear, I'm going to show you States Exhibits 1.21, 1.22, 1.23, and 1.24. Do you recognize that car?
It looks like the same make and model car that I had.
And you don't dispute that you were down in a large wooded area on November 29th of 2022 at the time referenced in that photograph?
I don't really recall where I was, ma'am, but
You don't recall where you were?
right.
Okay. But just a moment ago, you said you didn't dispute that that was your path of travel that Agent Burney displayed for the jury, correct?
Correct, ma'am.
Thank you. I'm publishing to the jury. Photograph 1.1, rather 1.21. You saw Agent Sands testify, correct, concerning 1.117?
Yes, ma'am.
This is a Marathon gas station, correct?
I can't quite see it, but I believe so. Yes, ma'am. Yes, it is.
And there's also a business record attached there, correct?
Yes, ma'am.
That's from your Renaissance Bank records, correct?
I believe so, ma'am.
That was your vehicle, your card, and you that was present at the vicinity of 13689 East Oglethorpe Highway, Midway, on November 29th of 2022, correct?
I believe so, ma'am.
Nobody else swiped your card, right? That was you.
I believe so, ma'am. Yes, I do not have any reason to believe that was not me.
You didn't report your car stolen, right?
No, ma'am.
Didn't report your phone stolen?
No, ma'am.
Didn't report your wallet stolen?
No, ma'am.
So all along, you've always had possession of those, correct?
Yes, ma'am.
And it was your testimony that also you were told to turn your phone off, correct?
Yes, ma'am.
And in fact, you saw Agent Burney demonstrate the time gap of approximately 2 hours when your phone was off and still in the area of the Portal Hunting Club, correct?
I'm not sure where the phone was during that time, but because I believe it was turned off, but
What was with you, wasn't
Right.
it?
yes, ma'am.
Okay. It was off, but on your person.
Or in my car.
Okay. And it's your testimony that you brought a black and a gray tote to that area, correct?
Yes, ma'am.
And so your testimony, that's not your tote?
Demonstrative evidence.
Yes, ma'am, it is.
That is your tote.
No, ma'am, it is not. My testimony is that it is not my tote.
So the other one, the gray one, that's also not your tote?
I would call that the gray one, ma'am, but I would I believe that that is also not my tote.
Just so we're clear. My apologies. These two totes are not your totes?
That is correct.
There are two random black and gray totes that showed up on November 29th of 2022 in the vicinity of the Portal Hunting Club, and they're not yours?
Objection, that's the answer.
Overruled.
I'm not sure when they turned up, ma'am, but they are not mine. I can explain why if you would like.
You know how the process
Oh,
works, Mr. Casotis.
Okay, ma'am.
he wants to explain why they're not his totes.
I say knock yourself out. Go ahead.
You heard the testimony that Mindy's blood was inside of those totes, correct?
Yes, ma'am.
And you heard the testimony that there were cleansing wipes recovered in the vicinity, right?
Yes, yes, ma'am.
And also the knife.
Yes, ma'am.
So to your testimony, this is not the knife you purchased on November 29th, 2022 at Home Depot.
That is definitively not the knife that I purchased at Home Depot.
Do you see the cleansing wipes on the knife at the photographs of the crime scene?
Yes, ma'am, I did.
To your testimony, you didn't clean this knife off, right?
That is correct, ma'am. I have never seen that knife before. It was introduced as evidence.
Oh my gosh.
This knife just happened to be there in the vicinity of the same black and gray colored totes that you referenced in your interview to law enforcement, correct?
I don't believe it just happened to be there, ma'am, but it was there.
And it was your testimony, correct me if I'm wrong, that you bought the deer processing kit to give to somebody as a gift?
Yes, to Mindy's younger brother, Matthew.
It was important to Mindy that you get him something he liked, right?
I believe so, but though I now have reason to question whether those messages were coming from Mindy or not.
But you don't have any reason to say otherwise other than that you're guessing, correct?
Correct.
But something so important to Mindy, you just left it at the house when you moved out, right?
I was extremely upset when I moved out and I left a lot of things there.
So that was a yes, you left it at the house?
Yes, ma'am.
You never gave it to Matthew?
No, ma'am.
You heard testimony from Samantha, correct?
Yes, ma'am.
And that was your third wife at the time, correct?
At the time, yes, ma'am.
How many women marry this guy?
You heard about the relationship leading up to you meeting her in person, right?
Yes, ma'am.
And you started talking to her as early as late September 2022, correct?
I believe so, ma'am. I'm not 100% sure, but that sounds right.
Well, you saw the text messages, right?
I didn't actually look at them that closely, but if they say late September, that would be correct. It was either late September or early October. I'm not 100% sure.
Those messages were not sent by Signal, correct?
Correct.
They were sent on social media, correct?
Correct.
Those messages were sent by you, correct?
I believe so.
Well, here. Let me give you two specifically to look at. 1.95 and 1.98. Let us know when you finish looking at them.
That's the dad, by the way, I think. I'm pretty sure that's the dad. I think I confused. Dad, Wayne, who gives blame for all of the fear and plotting against him that led him to all of the travels and the movies. And so many different things that seem odd but are now perfectly understandable, like Jim McIntyre.
I'm done, man.
and Dan.
Those are text messages or communications that you sent to Ms. Kolesnik, correct?
Yes.
And during those exchanges, there were several exchanges on a regular basis, correct?
Yeah.
And they started at the end of September of 2022, correct?
Yes,
and ultimately culminated with you going to see her on December 16th of 2022,
that sounds right. Yes.
2 weeks after your wife was deceased.
Yes, ma'am.
But you initiated that relationship before she was dead.
I wouldn't say initiated that relationship, but we were talking. Like I talked to many people online.
Well, you drove from Georgia to Missouri, correct?
Yes, ma'am.
And then
So you
from Missouri
initiated
to
it.
Pennsylvania to go see her, right?
Yes, ma'am.
How many hours was that?
Quite a few. I'm not sure exactly.
But you weren't just talking?
No, at that point we were, we had progressed into more of a relationship, but I'm saying that that wasn't how things had started in September.
Right, but on December 16th, 15 days after you told your wife's parents she was dead, you drove to Pennsylvania from Missouri, correct?
15 days after I learned my wife was dead.
October 22nd of 2022, you told Mrs. Kolyesnik or Miss Kolyesnik on 1.95, she had an undiagnosed heart issue that was aggravated by her pregnancy, correct?
Yes, ma'am.
Very sudden change in the way I thought life would look, but doing my best now to figure it out, right?
Yes, ma'am.
You were tugging on her heartstrings, weren't you?
No, ma'am.
You weren't trying to convince her you were single and available?
No, ma'am, I was not.
Be better if you said you were.
That was a very similar conversation to one I had with any number of people, male and female, friends.
What? This doesn't
Right,
help
you had a
him.
conversation going on with Joy when you thought Mindy was going to die in COVID, correct?
Correct.
So that was another woman you were chatting with that you told this jury was a woman you had a relationship with
Correct.
while you were still married.
While I was still married, ma'am.
But this one wasn't.
No, ma'am.
1.98, you indicated on November 8th of 2022, while terrified for your life and staying in the house exclusively but to run errands, going to spend this weekend in Virginia, then New York, Bedford, Hudson Valley area, then on to New England until after Thanksgiving. So hopefully going to spend a little time poking around and seeing how a few spots feel in terms of life there. That was not true.
That was not true, ma'am.
You weren't trying to convince her to trust you?
No, ma'am.
Why make that up?
That was something we were regularly told to do. Say that we would be in different places, and then if there was a concern, it would be somewhere that we weren't.
So Jim told you what to say in each of your text messages to Samantha?
Not in each, but it was something he would generally say, tell people that you're going to be traveling for the next 2 weeks. And then if there was a concern, it would be somewhere else.
I really want to see how Doug is doing right now.
After you found out that Mindy had passed, you testified to this jury you never got a single document of any sort from the doctors, correct?
That is correct.
You just told this jury that you were a JAG officer, correct? For 10 years.
I was.
You checked every detail, right?
Yes.
Verified everything, right?
Yes, ma'am.
You didn't get a single document at any point in any of the time after her death?
No, ma'am, I did not.
Death certificates, 1.68. They're registered with the state of Georgia. You're aware of that, right?
I am.
You never got a single copy of a document from a courthouse?
No, ma'am. I asked about it once and I should have followed up, but I did not.
You yourself as an attorney never got a single document.
No, ma'am. I didn't have any reason to have a document, and so I failed to follow up on it.
You were on trial for murder, correct?
Ma'am, I was not.
In anticipation of today, in your testimony, you knew you were on trial for murder, correct?
Yes, ma'am.
And you didn't bring a single court document with you.
Get
Well,
him.
ma'am, I believe the testimony is fairly clear that I was lied to about Mindy's death, and that I did not have a document because there were no documents.
You worked for APIS Security, correct?
I believe so, ma'am.
No W-2, right?
At some point I saw a W-2, but
But you didn't bring one.
no, ma'am. I believe there was one in Discovery, but I don't recall.
You do. You believe there was one in Discovery?
I believe so, ma'am.
Can you tell us what document that was?
I can't recall. I believe it was a tax document.
Was there a W-4,
I don't recall. I'm not sure what a W-4 is, ma'am.
an I-9,
No, ma'am.
no tax documents?
No. I-9s are for immigrations, proving that you're a citizen. So
What about tax records? You got paid, right?
it was paid into a trust, ma'am.
So you have zero records reflecting being paid by APIS Security, correct?
Well, I have the records that you provided to me during Discovery. But
1.84. You provided Samantha with an employment verification, correct?
yes, ma'am.
You indicated you worked for them February 12th, 2018 to present. That was January 12th of 2023, correct?
Yes, ma'am.
You never got a single paycheck?
Not paid to me, no.
So for 5 years, you worked for a company and got zero money handed to you.
Handed to me, yes, ma'am.
You opened a bank account, correct?
I've opened, can you be more specific, ma'am?
You opened Renaissance Bank account, correct?
Yes, ma'am.
That was the account we saw the records for, ending in 141, right?
I don't know the number, but I believe so.
You signed it, correct?
Yes, ma'am.
You went into the bank, right?
No, ma'am.
So that's not your physical signature on there.
It is my physical signature. I believe it was scanned and emailed.
It's your testimony you opened a bank account without going into the bank?
Yes, ma'am.
Okay.
I've done that a few times. It's not a big deal. These days, you don't have to go into the bank to open an account. Now, why he doesn't have an I-9?
Samantha with a driver's license, right?
With a photograph of one, yes.
1.86. This is the license you sent her, correct?
Yes, ma'am.
I'm showing the jury 1.111, which is the same photograph, correct?
Yes, ma'am.
Okay. You're aware that there are no records in the state of Georgia reflecting a change of name to Stark.
I'm aware of that now, ma'am.
Well, you would have had to change your driver's license, right, sir?
Yes, I assume so.
Delaware. This was issued January 13th, 2023, 1.112. That's you, right?
Yes, it is, ma'am.
Is that a current picture of you?
That was current at the time, ma'am.
It's current at the time.
Publishing to the jury. It's your testimony that you got one under the name Casotis because of a glitch at the DMV?
It wasn't a glitch, ma'am.
Well, you testified that the Social Security Administration told you it would update in 24 hours your name change, right?
They said likely 24 hours, though there was a chance it would be sooner.
So sooner still, right?
I hoped it would be sooner. That's why I went back to the DMV that afternoon.
Right, but in 1.106, you went on January 4th to change your name, correct?
Yes, ma'am.
So it's your testimony that from January 4th of 2023, some 9 days later, it still hadn't updated?
No, ma'am. So there's a difference between the court document, which you go to court to get, and then the Social Security office, which you have to go in there and bring a copy of the court document to start that updating process.
Right, but you said you went the same day as you went to the Missouri.
No, ma'am. I said I went to the Social Security office in Delaware after I returned to the Delaware area from St. Louis.
You submitted driver's licenses for Delaware, Pennsylvania, and a name change in Missouri, all within a week approximately,
I was trying to update my driver's license, yes.
in 3 different states.
No, ma'am, I had gotten a name change in Missouri, which had been our plan from the beginning. I was splitting my time between Delaware and Pennsylvania at the time, and I had gotten one license in Delaware that was not the correct name. I was going to be spending the next part of the next week in Pennsylvania. So the next business day, it was a holiday weekend. It was Martin Luther King Jr. Day. I went on that Tuesday into a DMV in Pennsylvania, and I got a license with what is now my legal name.
You remember it was a Tuesday, correct?
Yes, ma'am.
But you don't know your wife's doctor's name.
I was never given her doctor's name.
You didn't ask?
Ma'am, she wanted.
I asked you a question, sir.
No,
Did you ask?
I did not ask.
She was 8 months pregnant, you said, correct?
Correct.
You never visited her at the hospital,
Yeah, I was told not to.
and you listened?
Yes, ma'am.
First child, right?
Yes, ma'am.
Desperately wanted kids.
I wouldn't say desperately wanted kids, but I wanted kids.
You'd been trying since Heather, right?
Yes. Well,
How
on
many
and
years was
off.
that?
You know, Mindy and I didn't start trying to have kids immediately, but
Well, you testified there was a miscarriage in the middle, correct?
yes, ma'am. That miscarriage was in, July of 2021.
So for years, you had been trying to get pregnant,
Yes, ma'am.
and your wife was finally 8 months pregnant and terribly ill, correct?
Yes, ma'am. I believe
And-
so.
And you never went to see her.
No, ma'am. I was talking to her and checking on her, but I did not physically go there because I did not think it was safe to.
Well, just in your testimony earlier, you said texting, not talking.
Yes, ma'am. I use them interchangeably. I'll be more clear.
You never spoke to her.
No, ma'am.
Because you're
I
dead.
tried to multiple times, but we couldn't get a good enough signal to have a conversation.
And when you couldn't get her, you didn't go see her.
No, ma'am.
You're an attorney at the time of all of this, correct?
I don't believe I was at that time. No, ma'am.
I mean, you don't forget how to be a lawyer, do you?
No, ma'am. I hope not.
Right? So when you filled out this paperwork for the Missouri change of name, you indicated that you did not owe anybody any judgments,
That was my understanding. Yes, ma'am.
that there were no cases requesting money pending against you, correct?
Yes, ma'am.
Yet you stood in a court of law in front of a judge who told you when to be back to settle what was owed to Miss Thomas, correct?
Yes, ma'am.
And you didn't go.
I didn't go because I believed that was already settled.
You're an attorney at the time, right?
Yes, ma'am. At that time, I absolutely was.
You know, if you don't show up to court, what happens?
They would, if I still had a hearing there, if I had not paid that money, I would have been held in contempt.
You called Heather to confirm she got paid?
I did not, ma'am. And nor did she call me, nor did she come to the house that we had shared that I continued living in for 9 months afterwards.
You have been exchanging a series of emails back and forth with Heather for days leading up to that court hearing, correct?
I don't believe I had. No, ma'am.
It's your testimony you didn't.
No, ma'am.
Miss Thomas was following you repeatedly to the point that you thought that she was actually potentially one of the people causing you trouble.
Yes, ma'am.
But you think she just evaporated?
Because I believed she had gotten the money that she wanted.
Then tell us why she would be a danger to you.
At that point, I no longer believed that she was a danger to me.
When was that?
That was shortly around the time that I believe the payment had been made to her, and she stopped contacting me altogether. Never came by the house, never called my phone.
But you just told this jury that Jim McIntyre was looking into it for you.
He was, and he said that he had determined that Heather was not involved and that he had wired the funds.
Let's talk about your marriage license, the application 1.92.
Absolutely.
You listed people that are not your parents, correct?
At the time, I believed them to be my parents.
They're sitting in this courtroom now, right?
Yes, my parents are.
You don't disbelieve that Linda and Wayne Casotis are your parents?
Not anymore, no ma'am.
And with all due respect to your father sitting here, that's the man you moved 100+ times because you were afraid of?
I wouldn't say 100+ times, but yes, ma'am. We moved probably 50 times because I was
Good
terrified.
question.
Well, the 2 times that you just talked in direct testimony, you said 15 to 25 times twice and then moved countless other times, correct?
I wouldn't say countless other times, ma'am.
Well, your recollection was every time you moved a week, right? You could tell this jury when you
Wonder
were
what
in
Dad's
each different
drinking.
place, correct?
Vodka?
Yeah, I have because we move so often, it's actually pretty easy for me mentally to remember where we were when, because oftentimes we were only in a place for 2 days. So if you remember the 4th of July happened while you were in that house, you know when you were there.
But you don't remember your wife's doctor.
No, ma'am.
Let's just be clear, 2.32. This is Mindy, right?
Absolutely, ma'am.
During your interview with law enforcement, you didn't even ask what happened to her.
I did ask, ma'am. During the first interview, I asked what happened to Mindy, and Mr. Sands told me that at this time he did not believe that I presume you, the district attorney, wanted to make that information public.
You didn't ask about your baby either, did you?
No, ma'am.
Not once in 2 hours and 10 minutes, correct?
Yes, ma'am.
And not once in almost 2 hours in Liberty County, correct?
Well, ma'am, in Liberty County, as you all saw, was the time I was told that Mindy had not been pregnant when she died.
Until they told you, you didn't ask about the baby either, right?
No, ma'am.
You told your in-laws that your wife died December 1st of 2022, correct?
Yes, ma'am. Immediately after I was told, I went back to the house and told them.
And then the next day you went and got your car washed, or was that the same day? I'm showing 1.110.
I don't recall what day that was, ma'am.
Well, that is your car, right?
Yes, ma'am.
So after you found out your wife was dead, you went to the car wash. Is that right?
Apparently, ma'am.
Well, that is your bank record, right?
Yes, ma'am. Yeah, at some point I went and got my car washed. I don't recall getting my car washed, but I may have. It appears I did.
And you went and picked up some beer, right?
Yes, ma'am. I was drinking probably a scary amount at this point.
No, if your dad's sitting there, what are you
During your
thinking?
direct examination, I didn't hear any reference to 2.44 or 2.43, the rug, correct?
Correct, ma'am.
You don't dispute that this rug is the one you left the house with, 2.44?
No, ma'am. That looks right.
And 2.43 is what was there when you got there?
I believe so, ma'am.
And you replaced these because you said Rusty threw up on it?
Yes, he always had kind of a stomach that was sensitive to eating too much, and he was known to beg for food. So sometimes Betsy and Frank would overeat him, and he would get sick.
You didn't just clean the rug?
No, ma'am. Mindy had put it in a plastic bag and stuck it out back because it smelled. And by the time I had time
Mindy
to
did
try
it.
to clean it, 2 days had passed, and the entire thing smelled absolutely awful.
Had nothing to do with the blood that was underneath the rug, right?
There was no blood underneath the rug.
Well, you saw the photographs here, correct?
Yes, ma'am.
Is it your testimony that law enforcement somehow put Blue Star on the floor of that house?
Ma'am, I have no idea what blood that is or when it was there, and unfortunately, law enforcement never tested that.
Right.
True.
And so the blood on the futon that was Mindy's,
I have no idea how that blood got there, ma'am.
Okay.
I didn't spend a lot of time in that room, so
you lived in the house, right?
yes, ma'am.
It was also your testimony that initially Jim was an FBI agent, right?
I believed he was for, 2 years, over 2 years.
And at some point you determined that he was not, correct?
Yes.
You didn't move after you figured that out, right?
No, as I testified, we had a big argument about whether or not we should, stop dealing with him altogether.
You also didn't move after your father and uncle showed up at your house, right?
That is correct.
You were moving hundreds, or at least, my apologies, at least 50 times,
Yes,
correct?
ma'am. Yes, at least 50 times, definitely.
Over 7 years, correct?
Yeah.
How long was it?
I have 5 years. Yeah.
5 years. So over 5 years, you kept moving because that man was your threat.
Yes, ma'am.
And when he showed up at your door with your uncle, correct?
Yes, ma'am.
You didn't move.
No, ma'am. I asked to.
So at this point, you actually knew he knew where you were.
Yes, ma'am.
You ran out the back.
After I talked to Jim, yes, I departed via the back of the house.
Right. You said you
Parted.
called Jim, didn't you?
Yes, on Signal, but you can make voice calls or I believe even video calls now through Signal.
But yet,
Yeah.
when law enforcement spoke to you the first time in Pennsylvania, you said he just showed up,
Oh,
right?
No, ma'am.
Law enforcement specifically asked you, how did Jim know where to find you? And you said he just showed up.
No, ma'am. I said it didn't take him long to get there, which I thought clearly indicated that I had contacted him. But apparently there was some confusion on Mr. Sand's part. He then later said that I was clearly asked that twice, and I've listened to that interview about 40 times, and I've never heard it asked even once, clearly.
You've had access to all this material, correct?
Yes, ma'am.
You knew what the state's case was, correct?
Yes, ma'am.
No documents here with you today.
No, ma'am.
You indicated at some point that it was very important for you to figure out who of Mindy's friends would need to know, correct?
Absolutely, ma'am.
And you reached out to each of them, correct?
I did.
It's your testimony, you had no idea that Mr. Frank and Mrs. Betsy thought you were dead?
No, ma'am, I did not.
So I'm showing you 1.87 and 1.88. Well, take a look at them. You've seen them before, right?
Yes, ma'am. I saw them when they were provided in Discovery.
Do you see the email address on that?
I do, ma'am. Yes.
That's 8bis Limited, correct?
Yes, ma'am.
That would be the same address that you claimed was Jim McIntyre, correct?
I believe he had an APIS, but I'm not sure that I did not regularly email with him personally. So I believe at some point I saw an APIS Limited address for him as he was reaching out to Frank and Betsy, but.
Well, you just told the jury you worked for 8bis Limited, right?
Yes, ma'am. I believe so.
You got that employment verification from Marcus Jones at 8bis Limited, right?
Yes, ma'am.
And you believed you were working for Jim McIntyre, right?
Absolutely, ma'am.
That he was preserving all of your funds in a trust, right?
Yes, ma'am.
Did you bring the trust documents here?
No, ma'am.
In order to start a trust, Mr. Casotis, as an attorney, you know that there are actual documents you need to sign, right?
Absolutely, ma'am.
You never preserved any of those?
At some point, I lost them. I don't know exactly when.
Okay.
But I had them, and I provided them to Miss Thomas on at least one occasion.
Actually, when you went to court, you didn't provide the court with anything, did you?
I don't believe I was asked to.
That would be a no?
Yes, ma'am. That would be a no.
But you told the court you had $32 million.
Absolutely, ma'am.
Did you ever ask Jim to show you a copy of the check that he sent to Heather or the wire to pay her off?
Absolutely. I saw bank records showing a wire transaction to her.
And you saved all those?
No, ma'am. I believe I've been pretty clear about that.
Well, Heather was all but, from your description, stalking you for the money, right?
She was energetically looking for it. Yes, ma'am.
Okay. So energetically looking for it, you didn't think it was important to hold on to a copy of those?
No, ma'am. As I said, I stayed in that house for another 9 months. The house that Heather and I had shared when we were married, and never heard from her. She never stopped by. She never called my phone. I assumed that was over and done with.
At that point, you had moved and changed your name And your driver's license is in 2 additional states, correct?
No, ma'am, this is years before that.
Okay. Now, initially, I believe you told us that you contacted the FBI, and that's when Jim showed up, correct?
Yes, ma'am.
And if I recall correctly, what you said was you were very happy because normally you don't get any traction on a case like this.
Yes, ma'am. That was my fear.
But then Jim McIntyre, according to your testimony, spent the next 2 years acting as your basically personal assistant, social media provider, financial advisor, and Microsoft purveyor, correct?
I'm not sure I would use all of those, but he was somebody that we were dealing with very closely throughout all of this.
You thought that an FBI agent just decided to take you on with a case you didn't think that he was actually even going to investigate?
I had been worried that he wouldn't investigate it. I was very happy that it was being taken so seriously.
And it's your testimony to this jury that after 10 years in the JAG, you believed he was an FBI agent.
Absolutely. And I've dealt with law enforcement, both the state, the local, and federal law enforcement extensively. There was nothing that concerned me at that time.
Except your wife who's been beheaded and dumped in a ditch. That should be a little concerning.
So let me make sure I get this straight. Initially, you thought that the risk, based on your testimony, was because of the Washington Post article.
Absolutely, ma'am.
Then you thought it was Wayne, correct?
No, ma'am. Then we started looking at others. We looked at an ex-boyfriend of Mindy's, Heather, my ex-wife. Then we looked at a former boss of Angela's who had tried to assault Mindy. He was a very kind of rich and powerful man. And then...
I'm sorry, I didn't mean to interrupt you.
And it wasn't until after we had exhausted those leads that he started looking at our immediate families.
Looking at the jury, nodding. He just gave a little nod.
So when Jim McIntyre, you determined did not work for the FBI, he promptly told you how he knew to come and see you and Mindy, right?
No, ma'am. And that is one of the things I've thought about extensively over the last 27 months as this case has gone on, that as to how he entered our life, I never followed up. And there are frankly a lot of mistakes I've made over the last 7 years of my life that I spend a lot of time thinking about.
He just showed up at your house and said he was the FBI.
Yes, ma'am.
You heard testimony about Cameron Nelson's credit card, the Capital One card, correct?
Yes, ma'am.
It's your testimony that all of those charges were being made by Jim McIntyre?
The majority of them, not all of them.
The Uber Eats purchases that came to the house in Savannah, those are done by Jim McIntyre?
We were never in Savannah while anything was being charged to Cameron's card.
Are you sure?
Yes, ma'am.
Okay. And all of those transactions, the Uber car rentals, were those Jim McIntyre too?
The Uber car rentals?
Yeah, Uber.
I don't know anything about those, ma'am.
You never took an Uber on a credit card?
I have taken Ubers before. I have never, during this time, I never took an Uber, no.
So if the bank records show you taking Ubers and going places, that wasn't you?
That was not me, correct.
Okay. You have an Uber app on your phone, correct?
I do now, yes.
So it's your testimony you never had an Uber app on your phone in 2022?
In 2022, I did. I'm sorry, I thought we were talking about Miss Nelson's credit card. Are you talking about my bank records or Miss Nelson's? I'm just not clear.
I'm talking about your bank records.
Oh, okay, yes. My bank records, yes. There were times I took an Uber.
But you told this jury you were afraid to leave the house, right?
Yes, ma'am. Every time I went out, it was scary.
But you fought through the fear and jumped in an Uber?
If I had things that needed to be done, then yes. I thought it was my job to take care of those things.
You didn't call Jim and say, hey, Jim, I need a ride. Get me to this location. You're my security detail?
No, ma'am. Sometimes he would drive me places, but for regular errands, no. That was something that I dealt with. Either I had Mr. Frank Mebane drive me, or I would call an Uber.
Right, because on November 29th, you clearly went to Home Depot by yourself, right?
Yes, ma'am. At that point, I had a car, so I was not taking Ubers anywhere.
And it's your testimony to this jury that you never paid Jim McIntyre 1 penny. For how many years of service to you?
I believed that we were both benefiting from this.
That's not what I asked you. I asked you if you paid him.
No, I did not.
So in all of the years that he worked with you, you never paid him.
No, ma'am.
And it was your testimony you met Frank first, or rather you met Jim first in Virginia, correct?
Yes, Alexandria, Virginia.
And then he followed you to what state next?
We saw him multiple times in Virginia. Then later we saw him in South Carolina and in Georgia.
And then you said you didn't see him much.
Yeah, I believe I only saw him once, maybe twice when I was in Delaware.
Okay. It was your testimony to law enforcement, or your statement, I should say, to be clear, that Jim McIntyre handled your finances the entire time.
Yes, ma'am.
That included setting up all of your Airbnbs, correct?
Yes, ma'am.
Except the one in Savannah, because you bought that one, right?
Yes, ma'am. And there were two at the very beginning, one in Alexandria and one in Charlottesville that I set up personally.
Well, and don't forget the one in Hilton Head that you got for Frank and Betsy afterwards in your name too, right?
Yeah, that wasn't an Airbnb, but correct. I did set up that rental.
In the name Casotis, right?
Yes, ma'am.
While you were still afraid that people were coming after you. And your wife now was already dead.
Yes, ma'am.
And you're still using your name Casotis.
That was my legal name at the time. Yes, ma'am.
And you said when you got the $300,000 from Sony, you didn't pay Cameron, right?
Correct, ma'am.
You didn't pay Heather, right? You thought that was paid,
I thought that was paid, ma'am.
right? At that point, that money was the money you and Mindy were living on, right?
Yes, ma'am.
Jim McIntyre didn't control that money, correct?
No, he did not. He said he was monitoring it and taking actions to prevent it, but he did not control that money.
So you did have $300,000 to your disposal, at least on June of 2022.
Absolutely. That was a non-negotiable point for us, was that we get to control our own money.
Now, you talked about mosquitoes, right?
Absolutely, ma'am.
When you had problems with mosquitoes, that was when you first moved in, right?
It had started when we first moved in, but it got worse in, I want to say, mid-August.
Can you tell the jury how expensive the Airbnb was? How much did that cost?
I think it cost about $4,500 a month, but I could be mistaken.
You called the owner, right, to get her to fix the mosquito problem.
No, ma'am.
You decided to fix that yourself?
Yes, ma'am. This was a rule that we had had for several years.
At $4,500 a month, you took on handyman jobs.
Absolutely, ma'am.
It was also your testimony that Mr. Frank and Mrs. Betsy left the residence the Wednesday before Thanksgiving, correct?
Yes, ma'am.
And they returned on that Sunday?
Yes, ma'am. That is the best of my recollection, but I'm pretty certain about it.
Well, you testified under oath to that,
Yes,
right?
ma'am.
So if you weren't sure, you would have told us that,
Yes,
right?
ma'am.
There's also your testimony that your wife went into the hospital on Saturday, that weekend, correct?
I believe it was Saturday. There's a slight chance it could have been Friday, but I thought about this a lot. I'm relatively certain it was Saturday.
Well, you just again testified under oath.
Yes, ma'am.
It was Saturday.
Yes, ma'am.
You didn't give us an equivocation earlier,
Yes,
did you?
ma'am. No, ma'am, I did not.
And you said it was Saturday, correct?
Yes.
And you said that her parents came back on Sunday,
Yes,
right?
ma'am.
You never told them what hospital, right?
No, ma'am, I don't believe they asked either.
Okay, guys, Aiden has just arrived on
And
a
then it was your
bail. I'll be back
testimony.
after the
Okay.
hearing.
All right,
That
we're gonna join you as soon as
you
we see
talked to
this
Mindy
movement in.
Monday, Tuesday,
As
and
soon as we
Wednesday.
go, the
correct?
Zoom starts in
I
there, we
believe I
will
talked to
get
Mindy.
off this. As
Okay.
great as this is, I would say it's comedy hour, except for the
Uncertain.
fact that
I
a
don't
woman
think I've
is
been pretty
dead
clear
and
that I
beheaded.
don't know if it was Mindy or not. It was a message from Mindy's Signal account.
But you could have called her on the Signal account, right?
As I said, I tried to call her, but she didn't have a good enough signal where she was, so we couldn't hear each other.
But you never talked to her after she went in, so how would you know that?
As I said, I tried to call her, and when we could not verbally talk, we messaged each other via Signal.
And then you went to pick her up on December 1st, correct?
Yes, ma'am.
You heard testimony from Dr. Mondor that on December 1st, she was already dead, right?
Yes, ma'am.
You have no reason to disbelieve Dr. Mondor's estimation, do you?
I do not, ma'am, no. Which is why I have said I do not think I was talking to Mindy for most of that week.
And when you went to the birthing center and they told you that Mindy had passed, you didn't see Mindy, correct?
Correct, ma'am. I asked to, and I was told I was not able to at that time.
You never once referenced the baby during your direct examination when you talked to the doctor.
Well, ma'am, at this point, I've learned roughly a little over 2 years ago that there was no baby.
We didn't mention it to law enforcement either when they first approached you.
No, ma'am. I guess I did not. I believe we talked about the pregnancy quite a bit, but not specifically the baby.
Not on the first interview, Mr. Casotis. You didn't.
I'm relatively certain we talked quite a bit about how Mindy was pregnant and where I thought she was. Yes, ma'am.
Okay.
Okay. Oh.
Now, when you went to pick up your wife's ashes, you indicated that was in Alabama,
Yes, ma'am. Montgomery, Alabama.
and you gave him $5,000 cash.
Yes, ma'am.
No paperwork,
No, ma'am.
no name.
I'm sorry, no
He
name?
didn't give you his name?
He might have, ma'am. I'm not sure. I don't remember. It was a very brief meeting.
You received your wife's ashes on the side of the road, and you didn't get the man's name?
No, ma'am. I was pretty angry at him.
You're an attorney at the time, right?
Oh my God.
No, ma'am.
You weren't a lawyer at that time?
No, ma'am. I was not licensed at that time.
Well, you had put your license on hold, essentially, right?
Yeah, I had given up my Virginia license, but Massachusetts allows you to retire your license, and then if you want to turn it back on later, you just have to pay as if you were an active lawyer for all the years in between. So I am still to this day a retired attorney in Massachusetts.
You didn't forget how to be a lawyer, is my point.
No, ma'am.
Okay. And receiving your wife's ashes on the side of the road in Alabama for $5,000 cash, you didn't think you needed any documents as an attorney?
No, ma'am. I was pretty angry about the entire exchange.
That was a no, correct?
Correct, ma'am.
And I just want to make sure I understand, your car burst into flames in the condition we saw it in this courtroom on your way to purchase a house,
Yes, ma'am.
and you never bought the house.
No, ma'am.
That's a real estate transaction, correct?
That is a real estate transaction. Yes, ma'am.
Those require written documents, correct?
Absolutely, ma'am.
You lost $50,000, you said, right?
I did, ma'am.
You have no records of that?
Ma'am, you have all my banking records. You can see the EMD coming right out of it.
Could anyone tell me what
Right.
women see in this man?
Your
I'm
testimony
sorry.
is you don't have a record reflecting anything concerning that transaction that day?
Ma'am, you have all of my electronics, and that's how all these documents were. They were e-signed.
Well, actually, withdrawn.
This is why I'm wearing orange. Could just send him right directly to jail. He doesn't even.
You never
need
bought
to
the house, right?
Correct, ma'am.
Because you had a
Have
check
a
for
pre-sentence report.
$860,000, I believe you said, correct?
Yes, ma'am.
That you said burnt up, right?
Along with parts of me, ma'am.
And when Investigator Frost said to you, what was so important that was in the car that you opened the door? Do you recall that?
It was my phone, ma'am.
Not the check for $860,000.
No, ma'am. In that moment, all I was trying to do was call for help.
You didn't care about a check for $860,000?
I absolutely cared about a check for $860,000. At that moment, I was trying to call for help. I did not realize that my car was about to burst into flames.
Detective Frost had to tell you about the check, didn't he?
No, ma'am. I remembered the check. I thought we were talking about something else.
I just want to make sure I confirm something. The police report against your father for the name change in Missouri,
Yes, ma'am.
that was September 30th of 2022, the incident, correct?
I believe so, ma'am. Yes.
When you are a victim of domestic violence, as alleged, that allows you to seal the name change, correct?
Yes, ma'am.
If you had not had a police report reflecting the need to seal it being domestic violence, you couldn't have gotten it sealed, right?
Well, ma'am, I thought there were many other reports at this time, but yes, I did rely on that one when I got it sealed. Yes, ma'am.
You submitted it, right?
Absolutely. Along with my medical records, I believe, from the assault in Virginia.
Oh no, there's a phone in court again.
Microdots, that's the dad. That's his dad, okay? That he says is no longer his dad because he realized his new name is Stark. Maybe from Game of
And
Thrones.
Mr. Casotis, when you received Mindy's remains, you had testified that it was so important to you and Mrs. Mevin to figure out who would want to be notified, right?
Yes, ma'am.
You promptly called them to schedule them to be present when you distributed her ashes, right?
No, ma'am.
I have just one moment.
Yes, deja
Are we gonna
vu.
get redirect?
Supposedly Game of Thrones. Doug, redirect. Doug is going to need.
Jim is
I don't know
getting
who.
cooked right now.
I don't know who's going to need. Cat's talking, and I'm listening to. I don't know who's going to need
Big
more.
shout out to
more
Justice Serve TV. We
counseling.
love you guys.
We love you too. I don't know who's going to need more PTSD counseling, Doug or us. I mean, probably Doug than this guy.
Mr. Casotis, in anticipation of today's date, you located Mr. McIntyre, right?
No, ma'am.
So you've been talking to him basically on and off since what, 2017?
I started talking to him in fall of 2017, I believe, and we last spoke in, I want to say, mid-April of 2023.
And the records for 8BIS Limited, you subpoenaed those records in anticipation of court, correct?
No, ma'am.
You know what a subpoena is as an attorney, right, sir?
I do, ma'am.
I just don't know why we don't have like the JAG people.
And you knew that Mr. McIntyre was a majority investor, I think is the phrasing that you used,
clinic
right?
people.
That was what I believed, ma'am.
You hired a private investigator to find him?
No, ma'am. I hope the state would do that, but y'all didn't really care that much.
Y'all rag on me for representing Phil
Objection, Your
Spector.
Honor.
Phil
Move
listened
to
to everything
strike.
I said. This is a crazy client. Phil
It's our man.
Spector was not.
We see all bitch.
Well, we're approaching. The judge is over it. I think the judge is over this.
Yes, seriously, I asked the question seriously. I mean, and I've
And
seen
yeah,
judges
so
do
that-
this. Did he have?
That
Should he have
finding
sent him
changed
to
the
counseling,
appeal
to
because
an
of
evaluation
this. I remember the date range was something
before he
like,
testified?
it was reported that there was
Should he have sent him to an independent evaluation before he got on the stand to say, I'm voluntarily agreeing to testify? Because this guy clearly there's something that went wrong from birth.
Look at Doug.
We still love you, Doug. I'll take off my orange shirt when we go in for Aiden's. This was just for him to say, you better put one on quickly because you're going to be in prison pretty
I have
quick.
nothing further.
Uh-oh. Redirect?
Ladies and gentlemen, we're going to take a short break. This one's going to be very quick. So if you go out with the bailiff, we'll have you in back in just a few minutes.
Yeah, now stricken.
So this is a
Do you want to
quick.
watch the facial expressions of that again?
Oh my gosh. Look at the chats are going crazy, right? Did he really get $300,000 for a short story, a horror story? Do you know how hard it is to get $300,000 advance for a book? You mean famous as people are? I mean, you get, I know lawyers who've tried the big cases who've gotten $5,000 advances. This guy, yes, he did. Yeah, but I want to see, I want to see the documentation, Dizzy. I'm becoming I want to see it. I want to hear from somebody on the stand to say, yes, we gave it to him. I know, but I don't believe anything. I don't believe anything except for the fact that there's a poor woman, Mindy, who was found in a ditch with her body parts scattered and no head. And the reason why you cut off the head is so that you can't do a dental identification. Oh my goodness gracious. By the way, we are monitoring inside the courtroom where Michel Bryant went to go sit down to get a seat for Aiden's hearing. That's why we're here and we just thought we'd run this because we had run we started it last night. Kat Not Williams was on. She knows everything about the case. She's great. And you just can't believe it. And we said, why would he testify? Why would he testify? Because when he testified, by the way, it just comes down, and I've explained this to your client. Everything good that a lawyer's done, and Doug did some good stuff, you don't have a murder weapon. You don't know when she was killed. You don't have any video. You didn't do this. You didn't do that. You didn't do the other thing. You don't have this. You don't have that. All right. Yeah. You didn't test the blood. He had some good points to maybe get some kind of compromise verdict. But once your client takes a stand, none of that matters. That's not going to occur. You just start the trial. Basically, you're starting the trial when the client takes a stand. And that's the whole case. That's it. And we just watched this debacle. Not only is this case just out of control and crazy with Jim McIntyre, who at least Harvey the rabbit was kind of it was fun. I mean, it was, and all. But this whole case is unbelievable. So Doug's going to find out that maybe being a criminal defense lawyer is not so easy. Well, it wasn't easy when he had Yak Gotti either, but he was very successful. But sometimes your client can make certain decisions. Your client can decide whether they want to plead guilty or not guilty. That's totally within their purview. The client can decide whether they're going to have a jury trial or not have a jury trial. That's within the purview. The client can't make strategy decisions, but the client can decide whether or not they are going to testify. And that's something that a lawyer, you can't rope them down, you can't put them away, you can't sedate them. If they decide they're going to get on the stand, they're getting on the stand. And Crazy decided he was getting on the stand. How he could have been in JAG, how he could have been a lawyer, how he could have gotten this, how he could have gotten that, I have no idea. Okay, we can hear the court beeps, Missy. I can hear them. I can hear the court beeps, right? I'm muted. I'm muted. I shouldn't be muted. My microphone is on. Okay. All right. So we're going to be going into court for Aiden. Oh, not me. Thank you. We're going to be going into Aiden's hearing. And the reason why it was delayed, actually, what not too bad, is Tim Bradle was in another proceeding with another judge. And the question was whether he was going to get there by 2, 2:15, 2:30, later 3. And that's why. But actually, it gave us a chance to see Crazy in action. All right. Unbelievable. Georgia, we have Fonnie Willis. We have Young Thug. we have this case. We still have the case, Ashley Merchant's case going on. Not with the records, but with her client. I mean, Georgia seems to be I don't know. I mean, if you add all that up, does that equal Karen Reed? Does that equal what happens in Massachusetts? But we got a lot of stuff going on, okay? By the way, thank you last night for telling me. When I was telling my Alexa, who, by the way, is off right now, I turned her off to stop my timer because I was cooking tomatoes. I was slow roasting tomatoes for 5 hours last night. Apparently, when I say to my Alexa to turn off all timers, all of you who are listening and whose Alexas can hear me, I was told turn off their timers. So if I did that, that's something I didn't know. Can you imagine I can control your Alexa right now? If I said, well, I won't do it, I promise. But if I said, that would happen. I didn't know that, okay? Ashley Merchant actually is one of the guests that's going to be on once a week with Megan Kelly. Megan Kelly has a new crime channel. Ashley, Arthur Idala, who I actually spoke to on a matter this morning. There's going to be 5 people that are going to be lawyers that are going to be full-time, not full-time guests, but recurring guests. But that doesn't mean Ashley's agreed to come on our show too. We're just trying to set up a calendar for her to come on, by the way, just so you know. Yeah, congratulations to Ashley to be picked to be one of the people that come on all the time. Although it's not Ashley's channel, okay? We only got forced into this. I wouldn't say forced. Michel Bryant and I, we decided we had something to offer after Law and Crime decided they didn't want to have commentary. And we actually started this really as to do like 7 minutes a week because we are friends, and we were going to do like 7 minutes. We'll do something on politics, or we'll do something on our dogs. You see, I don't know if you can see this. I am wearing a poodle. My girlfriend, Beth McIntyre, who has a store up in Massachusetts, sent me this. This is Tubi. And I only put orange on, really. I did put orange on because I was listening to some of his testimony before we were coming on at 1, and I really couldn't believe this guy. I can't believe this guy. I can't believe how women fall for him. I can't believe how he's got this in his mind. I mean, for some reason, he is justified, in my opinion, killing his wife. I mean, supposedly an 8-month-old baby died. He never asked to see the baby. He never went. But no one has any records on that. Not even the prosecutor. All we have is this guy, Jim McIntyre. And it's beyond me. It's beyond me. You can't. If you and I wrote a screenplay on this and we submitted it to our editor, they say, go away. This can never happen in real life. It just couldn't happen. So when you want to think of crazy clients, this may be the one. And Michel Bryant and I talked a lot about people who dismember people now, and it seems to be more and more. You've got who's that shabusiness that talk about cray-cray, all right? That she had sex with her boyfriend and then with the collar, and then she just put his head in a bucket. She dismembered his head in a bucket. Cray there. You've got this case who probably cut off the head of his wife, smart enough to know that if you don't have the dental identification, we had that. We talked about Scandarito in Florida, which was a little bit different. It was an older guy, and he said he and his old father were doing drugs, and they had a cocaine filled hors d'oeuvre server, and the father overdosed, and he didn't know what to do. He thought he'd get blamed for the murder, so he cut him up in the garage, and he's the one who made the statement, it's a lot of work to cut up a body. You have no idea how hard it is. And the jury, I think, convicted him. He testified for mutilating a corpse, but not for the murder, because I guess there was drugs found. There was some body part that was found. Most of it had gone bye-bye in suitcases. So we're having this spate of people that cut up. It started in New Jersey, and we're trying to get Joe Tacopino on tomorrow night because we want to do this case again tomorrow night. Joe Tacopino had a case in New Jersey some years ago in Middlesex County, where I'm from, McGuire. She cut up her boyfriend, put him in a suitcase, and dumped him in the river, if I recall. But she cut him up in a bathtub in an apartment. So we want to get into the mind of people that want to dismember. It's one thing to get rid of a body if you think that somebody died accidentally, like we talked about drug overdoses, and people get rid of a body because they don't want to be, they think they're going to be charged with murder, and they probably would be if they were sharing their drugs. But what kind of mind dismembers part of a body and throws it away. I mean, that's what I really want to get into. So we're going to try to get Joe on. Joe's been on vacation because Joe has handled a dismemberment case. If not, we're obviously going to go through the closings, which are going to occur tomorrow. I don't think the closings are going to occur today on this because they still have to have the charge conference unless they had it last night. All right, so I do see the judge on the bench. Bradel's still not there, and that's been the issue. But if Aiden's went back into court, Bradel must be close to being on his way. But so let's continue our conversation. But let's actually talk about what's going to happen here. Last night, the Commonwealth, they have such clean hands, such clean hands. They must wash their hands with the washing fluid, the soap, the hand soap that's been recalled for bacteria. Because last night, with their unclean hands, they'd done 4,000 new pages just the night before, on the defense, on Aiden Carney's case. All right. We don't know if it's the 4,000 pages that were blank last time or what they are. But the 4,000 pages last night. Okay. Come on. I mean, really? All right. Yeah. I have such disregard, such disrespect for Cosgrove because of this. First of all, this case is a really important case because this case defines who is a journalist and what a journalist can do. And, for those of you that watch Fox News, right? Okay. You know how many times Fox News people have run up to people and put microphones in their face, in their doors, or out the driveway, or whatever? That's considered journalism, okay? But if Aiden Carney does it, I tried to get Aiden last night, and I think I showed you. Actually, I tried to get Jimmy, who's going to be on, Auntie Deb is going to be on our show tonight for about a half an hour. When I was discussing last night the whole idea of lightning buys, lightning deals on Amazon, it must have heard me talking because you could buy 30 pieces of rubber ducks for $14 on a lightning deal. So I don't think Ashley's in trial right now. I see that she was checking her schedule when I texted with her just the other day to see when she can come on. And she will respond to us as she always has. But I think that with Megan's show premiering yesterday as the first day, that it's a little busy this week. And maybe they don't want to take the focus off Megyn Kelly, who's going to have sort of a competing crime shows with all of the law tubers that have been doing this. Okay, so Brooklyn, recent dismemberment, Chandler Henderson, 2 parents. Yes, I remember that. Joel Guy, 2 parents. She had one, which is the one that put the head of the mother in the soup pot and did it. Taylorship Business. Brian Walsh, yes, let's not forget Brian Walsh, because clearly there's a bone fragment in a hacksaw. I mean, I want to get into it. I think that's what I want to find. I want to find the forensic psychologist that specializes in the type of person, what type of person will cut up the body after killing somebody, okay? What type of person? I actually would love to interview Shabusiness. I actually bought that project, Too Long Crime, and I see now they're talking about it a little bit. And one of the producers said, "We don't think anybody's interested in that. Are you saying that we're wrong? That people that have experience? I don't know about you guys, but I really like to know what's the mindset. How do they get there? How does somebody get to that point that they can cut off the head of somebody? It's not a grasshopper. What's the animal that cuts off the head of the male after they have sex? That's what Shabusiness did, right? Okay, so that's what Shabusiness did. All right. Yeah, we could look at the forensic psychologist from the Johnny Depp case. I'd really like to get a forensic psychiatrist if I could. I'll look around. I'll check it around. Because that may be a special, different show than just going through the closings and going through again, and I don't know if there's redirect going on if Poor Duck's doing any redirect in his case in Casotis or not, and all. So let's see. Here we go. The Black Widow, but there's this long, oh my gosh. Come on, everybody, help me. Not the Black Widow. It's a long green animal, and that's what Shabusiness did. Anyhow, it's a long green, looks kind of pretty, except that it's not very pretty. I see that, by the way, Casotis is still sitting on the stand, I gather, right? I don't see his mouth moving, though. Okay. All right. Praying Mantis. There you go. Thank you, Sherry Berry 79, and everybody else. Grateful Little Farm. Everybody else. The Praying Mantis, right? It looks so beautiful, but the female is deadly after she decides to, have a young'un with somebody that she's picked. Okay. All right. So Kathy Bennis, the death in her case was the first trial. We actually heard that a little bit from Katnott Williams last night. Okay. So let's go back to, let's talk about Aiden right now. Aiden's case is extremely important because it is a First Amendment case, right? By the way, tickets are on sale for his interview with on September 12th with Jimmy. Right now, you have to have some kind of password. You have to be part of his group. I think they go open to the public tomorrow. I took a look at them. Some of the VIP tickets are already sold out, but it's a big venue and a nice venue. So, but here, and Bradel said this case is going to go upwards no matter what, because this case is important as to who is a journalist, all right, and what constitutes journalism. I think the statute, the intimidation statute, is unconstitutional, completely unconstitutional, because it talks about hurt feelings, all right? The intent should be on the person and what the person's intent was, the defendant's intent in terms of doing a specific action. And then, of course, you can talk about whether it had an effect. But the effect should be a serious effect, not, oh, I was so hurt. This whole idea of intimidation by talking to a window when no one's there and making like stupid, like we did with kids, as being witness intimidation, it's plain stupid, okay? Especially when the Commonwealth has people that clearly tried to convict an innocent woman, clearly withheld discovery, and still withholding discovery. There's still issues with the state police. We have a state proctor's gone trying to get his job back. And then they're spending more money and more money and more money, not on crime, not on real crime. And there's a lot of real crime that happens, it's going on, as we know, in the United States. But they're talking about this. They're talking about Aiden Carney. They put him 40, Microdots is about to do, Microdots, I don't know if you're still here, they're about to do a video to show how Aiden was set up to spend those 60 days in jail, all right? And it's ridiculous, okay? It's absolutely ridiculous that he spent time in jail, and there's an issue of a carpool, and these rubber duckies. I really wanted to buy them. Okay, I really wanted to buy them, and I wanted to. I was actually going to go to Massachusetts today, because anybody who has a rubber ducky put under their house or whatever, and that's considered intimidation when it doesn't have a message like I'm going to kill you. Here's what you do. You give a rubber ducky and you open it up and it says, I'm going to kill you if you testify. That's intimidation, okay? Especially if that's your intent, okay? But the rubber ducky brigade being intimidation is ridiculous. So anyhow, that came up on my lightning deal, probably because I was talking about it. But Massachusetts, their court, their top court, which, by the way, there was some talk that Judge Beverly Cannoni was going to go there. I don't think she's going to go there right now, okay? I don't think after this case she's going to go there. Hi, Joanna Goddins. Michel Bryant is there again, and you're going to miss him, by the way. But they've got some really serious cases that they take up, and they usually come down on the right side, especially on forensic issues. I can't imagine that if this case goes to the Massachusetts Supreme Court, that they will hold this statute up as being constitutional. All right, that's the first issue. That's a really important issue, okay? But, Aiden represents us all, because if it wasn't for Aiden, and somebody ragged me because they say, how can you support this slime or something like that, and it was directed at me, and I clapped back.
And 25 CR 88. Kearney is present. If the parties could please identify themselves.
Okay, let's go.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Good afternoon.
Timothy Bradle for the defendant, I bet.
Nice to see you.
Nice to
Timothy
see
Bradle
you.
for the defendant.
How are you? I'm Mr.
Healing
Kearney.
with me, Judge. This is my client, Aiden Carney in the middle.
Good afternoon. All right. What do we have today?
Well, we have a bit of an agenda here for you, Your Honor.
Go right ahead.
Can I go through?
Yeah, go ahead.
Thank you. Your Honor, we're back here on discovery issues that have been going on. As you know, the automatic discovery certainly is due at or before the pretrial conference, which was like over a year ago. And we've been going back and forth with this. And if you just peruse the docket, I'm not going to go through it because I know these kind of tedious discovery hearings are awful for everybody. But if you peruse the docket, you'll see all kinds of motions to compel. Yeah, sure.
Yeah, go ahead, Mr. Bradle. I'm sorry. I left my notes. I took some notes.
No, that's okay. I appreciate you taking.
Yeah, and then I left it in the lobby. So.
We're willing to wait for you, Your Honor.
No, Mr. Summers went to get it. Takes good care of me. Mr. Bradle, go right ahead.
Thank you, Your Honor. So if you peruse the docket, Judge, you'll see all kinds of motions to compel, and it's just not happening. It's just not happening. So putting the issue of, whether it's an intentional thing or a, just not getting it right kind of thing. Nonetheless, we need these items. They're exculpatory. If this was just regular discovery, I might ask for a ruling that the Commonwealth may not use certain items they haven't given us, but this is exculpatory stuff that we need. One of the most important highlights, Your Honor.
So I went through it. These are what my notes are. You want access to different items in a form that you can see on your computer, right?
Right. We can't open what we got.
You want something about somebody that's allegedly a government agent, right?
Yes.
You want digital copies of some documents. You want videos that were taken by the Commonwealth of the rolling rally, the Brady list, right?
Yes.
All right. Is there anything else?
Yes, Your Honor.
Go ahead.
There's a whole host of items.
Yeah, go ahead.
So the first thing, Judge, is that I don't know if you heard, but it was all over the media, but we got 4,000 blank pages after we were here last time when the Commonwealth said, oh, we gave them 5,000 pages. 4,000 were blank. And now the Commonwealth wants us to give back the thumb drive that has some things on it minus the 4,000 pages. So last time we gave something back, we never saw it again, and they still don't want to give it to us. And that's the Gattani extraction.
I read that.
The redacted extraction.
There's another motion, a pro se motion on that.
Yeah. So I'm sorry. Go ahead, Judge.
No, go ahead.
So it's been like 9 months, and we don't have the redacted extraction that the Commonwealth promised me. I look back at my emails on July 9th, 2024, saying it would be ready for pickup. And it just never happened. So now they are apparently doing a 180 in their filing saying, go get it from your friends, Mr. Carney. And I don't really understand that. I don't think it's a serious response. And the Commonwealth owes us the discovery, the redacted discovery. And I ask that you order that forthwith.
Okay. Let me hear from Mr. Cosgrove on that.
All right. Many of these issues, Your Honor, I addressed in my filing. I have been working diligently to get Mr. Bradle the discovery, despite some obstacles. If Your Honor would be kind enough to go through the list that you just went through with Mr. Bradle one by one, I will respond to them individually.
Yeah. Commonwealth video of the rolling rally.
All right. The Commonwealth has provided at least 2 copies of the video to the rolling rally. one of them in the format specifically requested by Mr. Kearney. The last time it was provided was, I think, about 6 months ago. The first I heard that he was having a problem with it was the motion that he filed on the last date. As I indicated to your honor in my filing, I had notified Mr. Bradel of dates that he could come over to the office, and we would attempt to show him the video and resolve that, which was his suggestion in the first place.
Oh, yeah, I remember reading.
And I got no response.
Mr. Bradel, when are you going to go over to see Mr. Cosgrove and look at this?
So, Judge, that's a separate category, okay? I don't think, you know.
Let me start with this. When are you going to go over to Mr.
Yeah, we'll be happy to go over it. We're not concerned with that aspect of it. We're concerned with the stuff that they were supposed to give us. We can put that aside, the stuff that they tried to give us.
Right.
And it didn't work, you know, that it's not the right format. Nobody can open it short of Bill Gates. And, you know, that stuff, I'm confident with our team, there's some really good computer people on our team that can figure it out. And we've said to them, just do this. And they haven't done that. So if we have to go over there,
Mr. Cosgrove has said to you, come to the office.
Yeah.
We'll do it.
Yeah, we will, and that's not what this hearing is about as far as we're concerned. There's a ton of other stuff that doesn't require that.
That's fine. Go ahead, Mr. Cosgrove.
And the second item, Your Honor?
Let's see. I have the Brady list.
I had indicated to Mr. Bradel that I would provide that information 30 days before evidentiary hearing or trial, whichever came first.
I think, and then you said you'd give it to him by September 3rd in your memo?
Yes.
I'll order that. I'll order you to give it to him by September 3rd. So that takes care of that.
What's next, Your Honor?
Okay. Let's see. We have, I think we get to then the, supposedly somebody working as a government agent.
Oh, that would be Catherine Peter, I believe.
Yeah. All right. So tell me about that.
Well, Catherine Peter is relevant basically to the Lindsay Gattani cases. She is a former employee, as I understand it, of Mr. Kearney. He and she had a falling out over issues that don't concern the Commonwealth long before this case was originated, and basically exchanged negative posts about one another. From time to time, she has emailed usually Lieutenant Tully.
No, I'm not interested in the specifics, but more so, I think in your filing that I have in front of me, you have replaced the defective thumb drive. Am I correct?
Yes.
Mr. Bradel, do you have that?
We do, Judge.
All right. So then that's taken care of.
Yes.
All right, great. All right, that's good. Provide.
Yes, sir.
Okay. So then we go to the next one, which is a digital copy of all communications from District Attorney Morrissey to civilian witnesses. And it gives a list of names. And then it says that from Mr. Bradel's point of view, that the Commonwealth hasn't provided complete discovery. Go right ahead, Mr. Cosgrove.
Well, I don't know what he thinks he's missing, number one. Number two, what the Commonwealth is obligated to do under the rule is to provide statements of witnesses.
Yeah.
It's not obligated to provide the electronic information which may accompany it, any more than when it turns over a photograph. It's required to provide who the photographer was, that sort of information. I think this information, I have an inquiry in, would be difficult to access and provide. The Commonwealth has spent literally days assembling statements of witnesses, which are voluminous because it includes all kinds of emails that the witnesses have made to the district attorney's office, and those have been harvested by means of electronic system called ETOS by using term searches, and then people have gone through them and screened them, and I have screened them for compliance with Rule 14, generously construed, and those have been turned over. I can conceive of certain situations where electronic information might be exculpatory, and I think that's an issue that can be raised on a email by email basis. For example, if it were, if you had an email from somebody and their location at the time that they sent the email undid or provided an alibi or something like that, that would be exculpatory. It should be turned over. But in the ordinary course, all this does is provide information to the defendant that is irrelevant and is not required to be turned over. I think these are issues that can wait for a determination as we approach trial as to whether something is material and admissible.
Okay. Mr. Bradel, can you comment on that?
Yes, Judge. So this is the metadata issue?
This is the individual, well, it's a digital copy of all communications from District Attorney Morrissey to civilian witnesses.
Oh, yes. Okay. Thank you, Your Honor.
And it lists a whole slew of people.
Sure. So, Judge, the Commonwealth in this case has been going to the mattresses, so to speak, to keep this stuff from us. And meanwhile, the employer of the special prosecutor has released a FOIA of these items, which, just to move ahead for a sec, the fact that they released all this stuff pretty much obliterates this Commonwealth's impoundment privacy argument. But while we've been going back and forth with all this court time with keeping things secret from the defense here, the district attorney's office released 4,000 text messages from Trooper Tully as a FOIA request to the general public, while we, as defendants in a criminal matter with constitutional rights attached, have got nothing. So it's out there, this FOIA request from the employer of the special prosecutor, but not from this special prosecutor. So in terms of the integrity of this stuff, we need the special prosecutor here to give us the items in the context of this case.
The 4,000 text messages, were they related to this case, Mr. Bradel, or related to other cases?
Well, it's relevant to the Reed matter, to our matter, it's all the same alleged victims. It's actually emails, not text messages.
Okay.
But it's 4,000 pages of stuff that we've been wrangling back and forth about. Meanwhile, the district attorney's office releases them in a FOIA like a week ago. That has been bandied all over media while we've been trying to get this stuff for a long time.
Okay. Let me
So
go to Mr.
yes, it's a good thing that we're getting it.
Yeah.
But we need the government in this case to give us what they are contending is that stuff.
Let me just go to Mr. Cosgrove for a minute. Mr. Cosgrove, were you aware of that?
The short answer is no.
Yeah.
It's, I guess, part of the price of having an independent special prosecutor, Your Honor. I don't work out of the office. I haven't been to the office within the last 2 weeks, I think. So I was not aware of that. I was aware that 12 news organizations had filed FOIA requests for information in the Karen Reed case.
Sure.
But I wasn't aware of what particularly had been released. I'll look into that.
Okay.
I will say that when Mr. Bradel says he's received nothing, that is flatly untrue.
Okay.
I agree, Judge. We got about 200 and something pages out of what was supposed to be 5,000. And
So
then,
I remember the last time we were here, Mr. Cosgrove, you had said that there were 5,000 pages, or some large amount of pages. I'm not going to say 5, it might have been 3.
It was about 5,000. I think it was 4,700 and something.
Okay. Was some of that blank, or?
Well, the only information I have with respect to that was a letter from Mr. Bedrow that arrived 5 days later, complaining that the bulk of those pages were blank. I do not know why they would be. I haven't been able to figure out why they would be. As a result of that letter, I went back to the DA's office and sat down with one of their electronics people and had them make an entire new copy off of my laptop. And I actually added a little material that had come in since, provided by one of the prosecutors in the Reed case. But the bulk of it was the same 5,000 pages. I then went through that personally with the electronics person sitting by my side and assured that each and every page was reproduced on the copy that I sent to the defendant. So,
have you sent that to Mr. Bradle or Mr. Bedrow?
I've sent it to Mr. Bradle, and I'm informed that he's got it, so I'm not quite sure why we're still talking about it.
got it yesterday, Judge.
All right.
So haven't been able to go fully through it.
Yeah, no, sure.
It supports all sorts of other things that we're here for as well.
All right. But you did get it. Okay.
Yes.
All right. Then the next thing would be, the next thing I see, and Mr. Bradle didn't think this was much of an issue, was the video of the Commonwealth surveillance from the rolling rally. Has that been?
I think we addressed that, Your Honor.
We can go to the office, and I'm sure that.
Yeah, okay, so that's fine. So that takes care of that, that's
Thank
good.
you.
And then,
Judge, before we move on, I don't want you to go too far off of this. So I know it's tempting to think that these 4,000 blank pages is the same thing as the 4,000 FOIA. They're different. So the first thumb drive thing with the 4,000 blank pages has been remedied, okay? But the FOIA thing that should have been given to us has never been given to us, but they're responding to FOIAs about it to everybody but Mr. Carney. So
I get that, but Mr. Cosgrove says he's gonna look into that, and I'm sure he'll give it to you.
Okay, so I just didn't want you to think that was the same.
No,
4,000.
I
Coincidentally,
didn't
it's different.
Yeah, I didn't think that.
Okay.
All right, I didn't think that. All right. Then I think it's just am I correct, Mr. Bradle? Is that the list, or are there more?
There is more, Judge.
Yeah, tell me the rest.
All right, sure. So within the thumb drive, the thumb drive that was just remedied and given to us, there's all sorts of attachments, and we have a disagreement about this. There's all sorts of attachments from Ms. Peter to the state trooper team and Mr. Melo, I believe it was. I don't think Mr. Cosgrove was on the case then, where Ms. Peter is repeatedly providing attachments of things to the state troopers, and she's literally working on videos for the state troopers that were exhibits in the grand jury.
Let me just hold on for a second. Yep. Mr. Cosgrove, is that part of the 5,000 pages?
Yes.
All right. So then there, you got it at least.
I wish I could say we did have it.
Yeah.
If you hit the attachment, you get that message saying nothing's there. I printed out a few of them, but I'm sure you can just take my word for it, Judge. It says no attachment, nothing found, et cetera, et cetera. They don't come up.
So that's a technical issue. I'm sure you can figure that out.
So I think it's worse. I think it's it's actually a lot. Sorry, Judge.
Yeah, just over again. He says you are good to go.
Yes. All right. I'll see you shortly.
Okay.
Thank you very much. See you in a minute. Thanks. Bye.
Bye-bye.
Bye.
So, Your Honor, it's actually...
When does Zoom?
Yeah. It's actually a lost evidence issue, Your Honor. It's not a, oh, gee, we can't open it issue.
Yeah.
It's gone. I think they lost the evidence. And for whatever reason, the attachment has been taken away on the other end, okay? So this is a real bit of prejudice and a distinct bit of harm to the defense that Ms. Peter, who is a government agent, who's provided, and we'll get to this.
Let me just
False
ask Mr.
stuff.
Cosgrove before you go into all of that.
Sure.
Mr. Cosgrove, to the best of your knowledge, has that been turned over to Mr. Bradle and Mr. Betterow?
Has what been turned over?
Has any of the attachments that Mr. Bradle has just referred to?
Depending on what the attachment is, some of the attachments are visible simply by clicking on it. Others that specifically Mr. Betterow has inquired about, to the extent that I can resurrect them, I have sent them along to him and will continue to do that. I haven't worked my way entirely through his letter. But what happened, Your Honor, is this. Lieutenant Tully, who was the recipient of most of these, has a practice of not clicking on unsolicited links that are sent to him on email, so he doesn't access them. Now, if someone is sending him a reference to something that is online, he may check with that person and ask the person, where can I find it online? And then he will go himself and look for it online. For example, Mr. Kearney's YouTube presentations that were introduced to the grand jury. All of those were things that Lieutenant Tully found himself online. He may have been pointed to them by Ms. Peter. He may have been pointed to them by one of the alleged victims who complained about them, may have been pointed to them by multiple sources. But he never clicked on whatever it was that was sent, in part because he's working off a computer system, an office computer system, and there's caution about infecting it with unsolicited links. So these were never accessed, in effect, by the Commonwealth. If the links are now dead, we've never seen them. The links are dead presumably because whoever sent them took them off the internet. So
this would be some text from somebody with a link to a video or something else. And so you'd have the text, but not what the attachment is?
You'd have the text, you'd have a link to a video.
I get it, okay.
You click on the link now and nothing happens. Whether if Lieutenant Tully had clicked on the link 6 months or a year or 18 months, it would have taken him somewhere. Probably would, but he didn't.
Okay, gotcha. All right. Mr. Bradle.
A couple of things, Your
Go
Honor.
ahead.
A bit of a red herring to kind of suggest that, oh, some crazy person from the internet is sending me something and I don't want to look at it. That's not this. This is a government agent, Catherine Peter, sending them stuff that she's working with them. And you know, you mentioned an evidentiary hearing the other day, Judge. I think we should have an evidentiary hearing on this discovery stuff.
Yep, call Tully.
Peter, and let's find this stuff, because this is important stuff, and I'll tell you why in a second. But this isn't some unknown person. This is someone who repeatedly emails the state police and Mr. Melo, so in other words, and the government and the prosecution and the Commonwealth, and is actively assisting the Commonwealth, providing links to certain things. So they're gone. And so let me just jump ahead. One of the things that's missing is Miss Peter, and we know this from the new emails that we got last night. Miss Peter changed the titles of Mr. Carney's shows that were these 4-hour shows, Your Honor, that had innocent titles, like, you know, for example, Karen Reed case, where's Michael Proctor? Amiri King wants to fight Turtleboy, Canton updates, anti-Bev Canoni out of control. So it's a title that encapsulates a 4-hour show. That was his work. Ms. Peter changed those titles, provided it to the Commonwealth, told Lieutenant Tully in the emails that we have about changing the titles. So they knew. And then they put those titles in as exhibits. We found this out, of course, after the McCarthy-Odell motion.
Okay, somebody has to give me those titles that she changed them to.
These titles are very incriminatory, and they suggest they impact Mr. Carney's alleged intent to intimidate witnesses. The titles were all changed, and I can proffer up a spreadsheet of the actual titles and then what she changed them to in these attachments that, oh, gee, now we can't open them. So do the math on that, if I may approach, Sean.
Yeah, sure. Thanks, John.
Can I have a spreadsheet, somebody?
We have now learned that we have a grand jury that was listening to these video clips with titles like, you know, I'm going to kick Colin Albert's ass. And that's just me paraphrasing, but nasty titles. Give me another copy of this one. Yeah. Trying to destroy Colin's life. The actual title is Commonwealth tells more lies about John O'Keefe's GPS data. That's his real title. And these were suggested to be Mr. Carney's expressions, which of course would be used as his bad intent. And they're false and they're lies, and they were done, and we know this from the emails, from this Catherine Peter person.
Yeah, so what does this have to do with?
So these are attachments that we can't open. There's an example of attachments that are exculpatory and incriminatory to the Commonwealth that we can't even open.
Not only that, it says it's intent on behalf of Aiden that doesn't exist.
You
Judge.
can't open up any of these.
No, I'm sorry. That's if you wanted to see for yourself. But the other two columns are what Ms. Peter made those titles.
Yeah, no, I get that.
And then the regular
Yeah, no,
title.
she changed.
Yeah, and that was used.
This document she changed.
That was published to the grand jury as Mr. Carney's work. And it was even argued in Mr. Cosgrove's, one of his recent filings, he argued that, about how these things are so aptly titled, is what he wrote. You may remember that. And this is all false evidence.
Okay.
So, you know, this
What are looking for us to do with it, though?
I'm looking to ask to take you up on your offer to have a hearing on an evidentiary hearing where we bring these people in and we get to the bottom of how Ms. Peter's work for the Commonwealth went. And that also impacts, and see, this is all interrelated, Judge. We want Attorney Melo on the stand for this too, because he's the one that presented this false evidence
File a motion
to the grand
for all
jury.
this. I'll take a look at whatever you file, but I think we're kind of getting off track a little bit in terms of what the Commonwealth owes you. That's what I'm concerned.
Okay, I know, I hear what you're saying on that issue, but we did file a motion to disqualify Melo, who's been, you know, not able allegedly to be here, but he can be on Zoom. Whenever there's a hearing where Mr. Carney's bail might get revoked, he's right on the Zoom watching. But, you know, that's another thing we'd like to do here today is ask the court to schedule an evidentiary hearing on
Gotta write a motion.
we did, Judge, I filed two.
For an evidentiary hearing? Is it a new one?
Yes, a motion to disqualify. We have two pending. In fact, Judge Rayburn, I believe it was, set the hearing, and he alleged that he was sick and couldn't come, and it's been in abeyance forever. So we have, Judge. I don't want to, you know, bury the court.
Sure.
The judge say he just wants to see Mr. Cosgrove. Come on, Brado's doing a good job when the judge says write a motion. We did. Oh my gosh, I want an evidentiary hearing with Melo, with Peters, with Tully. Go Tim Brado. Go Tim Brado. If you presented false evidence to a grand jury, you changed the titles of Aiden Carney's shows to suggest that there was intent to intimidate by changing the titles and presenting those titles to the grand jury. This judge shouldn't be outraged at Tim Brado and making him go through the hoops. He should be outraged at Cosgrove and saying, wait a second, You have the titles, you have grand jury testimony, you change the titles, and you present a false grand jury testimony. I want a hearing right now. I want you right here. And quite frankly, if they did, they should be, in my opinion, indicted. Okay, you wanted a rant, you're getting a rant. This is outrageous. Go Cosgrove. This is unbelievable what we're hearing today for the first time. And all. And that there's videos that are missing.
How everything's interrelated. And with respect to the disqualification issue, this is another issue where Melo's involved in this, what we would contend is a conspiracy to put false evidence in front of the grand jury that we figured out. And it was used and argued it was a misrepresentation of Mr. Carney's intent. Because when you would put a title like that on something.
So this is what I'm trying to get you back to, though, Mr.
All right, go ahead, Judge.
What do you need? What else do you?
I want an evidentiary hearing.
Grove has as the special prosecutor that he hasn't turned over to you. We went through that list of items. I just want to get you back on track.
Sure, okay. So, Judge, there's a November 1st email that we can't get the links off of that, and that's important. If I could just have one moment.
Yeah.
And that's the exact email with the links to this, fake links to this that we can't open. And it's not a thing like, it's not a thing where, oh, well, let's go back to the office and fix it. It literally says, Google Docs, it says, sorry, the file you have requested does not exist. So it's gone.
Okay.
So why did this person make it go away? And I think we know why, but that's why I want to ask you for that hearing too. But so we want the government to, in writing, tell us what links they have and what links, where did they go? We want them to respond in writing to why there's lost evidence.
Okay, let me just talk to Mr.
They have what we have, and they can figure out where they went to the same extent that the Commonwealth can. The Commonwealth has not deleted any links.
All right, I'll take that under advisement. What else you got?
It says, Judge, literally, the files have been deleted.
Okay.
It doesn't say they've been deleted by the Commonwealth.
So would the court consider ordering the Commonwealth to, we'll tell them what links we can't open, and they need to give some sort of an explanation why this is lost evidence.
Why don't you give us a list of the links that can't be opened?
All right, thank you.
And send it to Mr. Cosgrove. And Mr. Cosgrove, I just ask perhaps if you give us an explanation as to why they can't be opened.
Sure, I will give you an explanation. I will consult with our experts,
Yeah.
but I can almost guarantee, Your Honor, that the explanation is going to be that whoever is at the other end of the link removes the content.
That very well might be it, but I think it would, I think if it was in writing, it would probably be the best.
Yeah, I'm happy to do that, Your Honor.
That's great. What else, Mr. Brady? What else?
So, Judge, we talked about the Kearney extracted, redacted extraction, excuse me. So can I get a copy of that? We don't have it. We've been looking for it for 9 months. Can you order?
What is it, the redacted?
The redacted extraction.
Okay.
Of her phone.
But you had the document at one point.
We had it. Judge Krupp ordered us to destroy it and give it back, which we did.
Yeah.
And just 9 months ago, we never got it back.
The redaction back.
Right.
Okay. Mr. Cosgrove.
I object.
Okay. Tell me why.
Well, there's a long history on this, Your Honor, and I went into it in one of my memoranda at length. In the original course, the Commonwealth and the defense entered into an agreement that they would return the original extraction and that we would provide them with a redacted version limited to those things that we felt they were entitled to under Rule 14. I asked Lieutenant Tully to prepare that. He did that. I sent Mr. Bradle a notice. I don't recall when, but the date is in my memorandum saying it's available at the office come over, pick it up, or let us know how you want to get it. And I believe I also indicated that there was some additional material on the thumb drive with that extraction. Mr. Bradel never picked it up. In the meantime, came back to court for various reasons that are, I believe, still presently impounded, although I believe Mr. Kearney referred to them on one of his YouTube shows. For various reasons, Mr. Bradel indicated that he needed to keep the original thumb drive. Those reasons were unrelated to any issues in this case, but I was persuaded that he should be able to do that, at least temporarily. We struck an agreement with respect to the use of that thumb drive, and there was a subsequent reduction of that, or a modification of that, to writing at Mr. Bradel's request that was endorsed by the court. And then in the Commonwealth's view, which the defense, I believe, still disputes, Mr. Kearney immediately went out and violated those restrictions. So I then filed a motion in front of Judge Krupp requesting an order that the thumb drive be returned. Now, at that point, Your Honor, the defense had the full unredacted thumb drive in its possession, custody, and control for some 9 months. Mr. Kearney had publicly stated on his YouTube presentations that he had provided the contents, a duplicate of the contents of that thumb drive to any number of other people. But the physical thumb drive was ordered returned by Judge Krupp, and it was returned. In the meantime, the defendant had been presenting what I would consider to be various material irrelevant to the case, designed to embarrass and humiliate Ms. Gattani. There was a reference, for example, to her DoorDash orders. There was the defendant picking out a phone number more or less at random and said, well, here's a number that she apparently calls a lot. Let's see who this is, and calling out the number live and dialing it live on his YouTube show. There was a reference to her ex-husband's daughters, if I have it correctly, and what they thought of Ms. Gattani, and so forth and so on. Judge Krupp allowed that motion at a provision that I agreed to, but I think was initially suggested by Mr. Bradel. The defense was allowed 2 weeks before they turned the thumb drive over, or approximately that amount, to take notes on anything they thought was relevant on the thumb drive, and then it was returned. As far as I'm concerned, they had it. They had an opportunity to examine it. I assume they did examine it. If they have time to go into the kind of trivia and side roads that Mr. Kearney went on to. I don't think at this point that the Commonwealth has an obligation to jump through further hoops and re-provide them with a different version.
All right, I'll take that under advisement.
May I be heard on that?
I think you already were, but I'll give you 30 seconds. Go ahead.
Yeah, Judge, there's no violation. If there was a violation by my client, I say bring it on. There's never been an allegation of a violation. If there was a violation, you know this Commonwealth would have done something about it. There was never a violation. They agreed to give it back. We don't have it. We were allowed to take note of it, but we were ordered by Judge Krupp to destroy it and not have any of it until we got the redacted one back.
Let me ask you this. Did you have it for 9 months?
Yes.
Thereabouts?
Yes.
Did you have a chance to look at it?
Yes, we looked at it, but we were told to destroy it. We don't have any evidence from it. It's destroyed. We were told, ordered by Judge Krupp to destroy it. We need another copy of it. We need the extracted copy of it.
We need the redacted copy.
Hey, we're happy to take the redacted copy,
That's
of course.
fine. All right, under advisement.
All
What
right,
else you got, Mr. Bradel?
Judge, so Just have one moment, please.
Yeah, no, take your time.
Judge, impoundment. As I alluded to earlier, the fact that the sovereign of the special prosecutor here has already released.
I know you don't want me to talk over the judge, but if I'm Aiden Carney right now, I'm filing a civil rights suit against 3 people and the state.
Judge, I would say that I don't think it matters, Judge.
Individuals, not this entity.
Well, it's a similar examination, Judge, okay? It's a protective order. Things are impounded by either a judicial order keeping judicial documents private, or you could say, and I think the parlance is that if something is under a protective order, it's impounded from view from people.
Right.
So I think it's just sort of a parlance issue. I think, frankly, the government was splitting hairs when it was trying to say that.
But you have all the documents, right? Everything that's under a protective order, you have as Mr. Carney's lawyer.
Judge, we have the documents that are under protective order because, as I alluded to last time, we're sort of under the gun of having to agree to it to get them, and we need these documents. So at the time, but this is a serious deprivation of the public's right to know, Judge. The public is the victim here, and these are documents that are kept private for no good reason. Whether it's you want to call it an impoundment or a protective order, there's no legal basis for it, Your Honor. As I said last time, things that show government malfeasance.
What's the basis for a protective order, though? We were discussing that today. Do you have any case law that you could point to on exactly what it is that the government, the hoops that they have to jump through to get a protective order?
Judge, I filed 8 pages on it last time.
Yeah, but give me some of the cases that you think are the most important. Because that was actually something we were working on today, trying to.
Well, Judge, the first order of business on that is that the burden's on the Commonwealth here.
Yeah, no, I agree.
So,
I agree. Maybe I should ask that question to Mr. Cosgrove.
Yes.
I'll ask it to you first, and then I'll go to Mr. Cosgrove, because the burden is on the Commonwealth. I agree with that. But these protective orders are already in place. So I understand you have the constitutional argument that you and Mr. Betterow have profit about the public's right to know. I get that part. But just in terms of a practical.
Thank you. Yeah. 1 second, please, Your Honor.
Yeah. No, take your time.
Finally, the judge says, maybe I should ask Mr. Cosgrove, because why was the protective order issued? Is it still needed for some reason? This is ridiculous.
Aiden Carney's motion to release case documents from impoundment, paragraph 3, New England Internet Cafe LLC versus Clerk of Superior Court, Suffolk County, 462 Mass 76. Public has a right of access to judicial documents and a right to understand and observe the operation and work of the judicial branch. They're presumptively public documents. There's a common law right of access to judicial records. So that's sort of that's where we start, is that these records need to be in the public's view. And so the burden is on the government to say why. And then just to carry through, just going to allude to what I said last time, is that when there's corruption or malfeasance, embarrassment, that's not a reason to hide documents from the public. That's a reason to show the documents to the public of the government's missteps. And in this case, there's been a lot of them. And that's really what the government is saying, like, oh, we can't have Mr. Proctor's emails because there's a safety issue. There's always a safety issue. It's either children or a safety issue. There's no safety issue. There's no children involved. It's just embarrassment. He's well on record to show all sorts of horrible things that he's said in his texts or emails or wherever. But and so the idea that we're going to hide any more of it is ridiculous. And the other issue, Judge, is that of the ones that we get, there's never the full story. There's like one screenshot of someone's past, and then there's no responses. There's no, there's just a one little thing that they hope we're going to look at and be satisfied with. There's never any context to this stuff. So that's another discovery aspect.
Let me give the floor to Mr. Cosgrove then about the protective orders. I agree with your filings, Mr. Cosgrove, that these are protective orders as opposed to impounded. So I'll start with that.
All right, Your Honor, and let me just say, as I previously indicated, the release of certain public records is new to me. If Mr. Bradel wants to go through the public records that were released and compare them with the material that is presently under protective order and identify any of those particular things, I'm happy to assent to their release from the protective order, because obviously if they're out there, they're out there, and the protective order isn't really serving any purpose as to those particular materials. Now, with that said, in terms of cases, Your Honor, I would direct Your Honor's attention to the case law in particular cited on page 2 and 3 of my brief that talks about the validity of discovery orders in terms of discovery protective orders as opposed to things that are actually documents filed with the court. I think that's the pertinent case law to direct you to.
Okay.
I would also, Your Honor, like to direct you, if I could, to a YouTube presentation, which is essentially a commentary on the opposition I filed. Mr. Kearney did about an hour and 10 minutes of his own commentary on my filing. It's in YouTube episode 795, entitled, and I'll leave it to the defense to correct me if I get the title wrong, Cosgrove Gets Frisky, What Happened on the Cape, Twitter Shenanigans. And if you start at about 141 at that presentation, and if you can stand it, Your Honor, follow through to about 350, you'll hear Mr. Kearney's explanation as to what he wants these matters released for. And I would characterize his comments somewhat tendentiously as saying, apart from some quibbles about whether I got the titles of his YouTube shows correctly, Mr. Kearney's response is, everything Cosgrove says I want to do with these documents is exactly what I want to do, and so what?
Okay.
Well, Judge, if you look at my filing, there's about 35 cases in there that talk about all this stuff dead on point. And there's no Turtleboy exception to the First Amendment, okay? Everybody out there has got this stuff, and Mr. Carney is not allowed to look at it or use it. It's ridiculous. Every journalist on Twitter is citing this stuff, and he's got to sit here. The guy that broke half of the stuff in the Karen Reed case, he's got to sit here and not touch it and not do anything. It's ridiculous. It's totally abhorrent. And
so these 400 things that were released on the FOIA request.
4,000.
4,000. 4,000. Oh. Do you have a copy of those?
Everybody's got a copy of those.
Yeah.
I don't have a copy, Your Honor, but I assume I could get it.
I'm not surprised.
All right. Perhaps, I know it's voluminous, but
we can give you a link, Judge. It's easy. It's nothing.
Okay.
You like a link?
Yeah, that's fine. If you could just maybe write it out.
No problem.
All right. Do we have anything else?
We do, Judge. I'm sorry.
What else we got?
A lot here today.
I just would like to make one more submission.
Yeah, go right ahead.
With respect to the issue that we're on. One of the points that I made, Your Honor, in my memorandum is that there's a cycle here, which is that Mr. Kearney continues to post things about the witnesses in his case and the Karen Reed case on a regular basis. That provokes typically the witnesses to complain to the district attorney's office. That generates statements which need to be turned over in discovery. And I made the point that turning over much of this material, I don't know what public interest there is, for example, in an email where Someone says she received an anonymous threatening phone call, which she attributes to a Kearney post, whether rightly or wrongly, other than to, I just don't know what the public interest is in that kind of thing. The public does not have an interest in going through everybody's cell phone, underwear drawer, et cetera, et cetera. So just to drive home the point that Mr. Kearney is continuing on a almost daily basis to publish tendentious commentary about these people, I want to call to your Honor's attention something that came to my attention this morning that he posted 24 hours ago. If I could.
Yeah, let me take a look at it. Thank you.
I think he missed a few of his usual targets, but most of them are there.
So now he wants
I'm
to
not
use
suggesting
things
that
that
this is a
Aiden said on
violation.
his show last night.
I'm not suggesting that it's criminally actionable.
Then why are you giving it to him, asshole? Excuse me.
I am suggesting that it would help Your Honor conceptualize the use that he's going to make to any of this material that's under protective order.
Yes, Cosgrove is trying to decide what's in the public interest, what we want to know about. That's basically his argument just now.
Okay. I looked at it. I get the point.
All right, that's all I have, Your Honor.
All right. Mr. Brito, what else you got?
Judge, I can, just watching you peruse Mr. Carney's publications, okay? Thomas Paine, Samuel Adams, Mark Twain would be spinning in their graves if they saw that a judge was looking at First Amendment protected satire, jokes, criticism, as if there's some risk that this stuff should be sanctionable. It's just completely antithetical to the First Amendment, Your Honor.
I don't want Mark Twain to feel poorly about me.
Really?
So,
Judge, it's just ridiculous. That the government, you know, proffers that as some sort of evidence of something is just completely beyond the pale, okay? This is all First Amendment protected.
I get your point. I get your point.
So
you've made it very well.
So there's a few more things, Judge, about this impounding these.
The impoundment I get. So I get your arguments on that.
One little
Do you have
fact.
any other discovery issues?
Yes.
What else
Can
you
I
got?
give you one quick fact?
Yeah.
These people that the government is trying to protect with these impoundment orders that they need or protective orders, they're doing interviews. The McCabe, the Alberts, Proctor, they've all done nationwide interviews. And yet the government wants to say, oh, we need to protect them from safety because of keep their stuff private. They're doing interviews. So that ship has sailed, Your Honor. All of their stuff needs to be unimpounded for our use, for our ability to use it without these constraints, and for the public's right to know, Judge. It just needs to be out there. There's no reason to keep it.
No, I get your point. All right. Is there any other pieces of discovery that,
Yes, Judge.
that you want to argue about? Because I have, I got some other things we have to do, some other cases. We have 2 other cases left. Mr. Bradle, I don't want to rush you, but
going back to the Melo issue, Judge. So Prosecutor Melo was the one that was working with Ms. Peter on these phony clips. And we need his emails too on this stuff. And I hope you're not going to say, oh, okay, file a Rule 17. Because I did that with respect to Morrissey's emails. And I was told by Judge Krupp, and I think it's the law of the case now, that no, that's a Rule 14 issue because it's in the possession of the prosecuting authority. So it should be Rule 14 discovery that Melo is communicating with Kate Peter, and it's been undisputed and it's been revealed in this case 100% that Melo's been talking on the phone with the other complainant here, Gattani, and we have only incomplete screenshots and inconsistent screenshots with respect to what's on the phones versus what really happened. And we need a written explanation from the government as to why there's inconsistencies in the discovery, and I'll tell you what that is in a second. But also, we need the full text report. We have these cherry-picked little texts, and like I said before, it's obvious that it was a string, and we get like one email with no responses or no prior context. And it's like they're hoping we just go away as they give us one thing. But it's not, the context isn't there, the full email strings aren't there. And we've made this complaint many times and it doesn't go anywhere. So I'd ask that you order the Commonwealth to either give us the stuff or respond in writing why they can't find it, don't know what I'm talking about, or whatever their position's gonna be.
These are the Melo emails you're talking about?
So we want Melo emails because he's talking directly to Gattani and Peter.
Yeah.
And we have a couple snippets of them, but it's clear there's other ones from the context that we don't have.
All right, I got you.
Yep, thank you.
All right, Mr. Cosgrove.
Well, I believe I turned over the Melo emails in the last round of discovery, and that generated a chiding letter from Mr. Betterow saying that you've had these for a couple of months now. We should have got them sooner. So I'm not, so far as I know, they have the Melo emails.
Right.
Okay. That being said, I think we should pick another date.
So Judge, just the last thing on that.
Yeah, no, go ahead.
Sorry.
No, go ahead. That's fine.
For example, Judge, there's a very important group text between Morrissey, Proctor, Tully, and others. And we have like one email from it that points up an extremely provocative issue relative to Proctor saying, why don't we just arrest them about my client? And there's no other discovery on it. There's a perfect example of cherry picking, why we need answers on this stuff. We need more. And there's also, Judge, there's inconsistencies in what we were given, where there'll be, and here's my last thing. Well, there's a list of text messages from discovery that we've been given. And then online, Ms. Peter, it's related to this Ms. Peter again, she publishes a string of text. It's the same string, and there's more emails, or text rather, there's more text in her string that she published online than in the discovery we got. So it's kind of a smoking gun that something was taken out of the discovery we got out of an extraction. And sure enough, we checked with Celebrate, the extractor has that ability to unclick a box to deprive the recipient of something, and the recipient has no idea. So there's a smoking gun here, Judge, that's why this isn't a normal case. I don't think you've ever heard me talking this deep about getting discovery. And here we are because of real reasons, Your Honor. And I hope that the court can give us this relief.
Okay.
Thank you.
All right, why don't we pick a date or anything further that you might have?
Does the court want to suggest a date? I haven't had too much luck suggesting dates myself lately.
We think September?
So Judge, in the meantime, would the court order production of some of those written responses? And
yeah, I'll issue an order on the written responses.
Thank you.
I'm sorry, what written responses?
I think he's asked you to give written responses as to, for instance, the links and things like that, what can be open, what can't.
Oh, yes. Well, I just indicate that Your Honor indicated that Mr. Breda was going to provide me with a list that I would respond to, so I would just hope your order would take that into account.
Fair enough, Mr. Cosgrove. Fair enough.
And Judge, just to the suggestion that, we should tell him what links we can't open. We can't open a single link. There you go. Compliant.
All right. Give me a date that works for the both of you.
September?
24th, 25th?
I can't do the 25th.
24th is fine.
That'll be at 2 p.m.
We'll see you on September 24th at 2.
September 24th?
Continue to September 24th at 2 p.m. for further discovery.
Okay, thank you all.
Thank you.
All right. While we wait for Michel Bryant to come out, since he is in the courtroom and listen to all of this complete nonsense, and as Michel Bryant said beforehand, he wasn't hopeful the judge was going to hold the Commonwealth's feet to the fire, and the judge didn't. Okay, so Michael Dots, I will be happy to talk more about what I think should be next steps, because I think this is absolutely outrageous and absolutely ridiculous, and somebody has to go a little further here. Okay, Grateful Little Farm, right? How do they get to decide what the defense is going to have? How is that fair? This is totally unfair. They have presented items to the grand jury. Let's start with the one that I think is the most egregious. They got information from their agent, Ms. Peters, right, about videos. You know, it's really Aiden's show that he's done, right? And she changed the title. She sent them off to Tully, and Melo apparently also got them. Melo then, from what I'm gathering, Melo may have been presenting to the grand jury. I'm not sure here. You can all correct me. Michael Dodge, you would know better. To the grand jury with the false titles that would implicate that or indicate that maybe there was an intent to intimidate, okay, by using a different title, which I think is bullshit to begin with. But let's say for a matter of course, that's a possibility, all right? Because one of them was, let's see if I can find, because I have so many. I didn't expect to take this many notes after the judge had that long briefing that he had. Let's see, hold on a second. I will find it for you as I'm looking. Okay. Yeah, she changed the titles to support the fact that she thought there was going to be intent to intimidate, like trying to destroy Colin's life, okay? Instead of something that Barry said, Karen Reed, where is Michael Proctor would be the title. She just sends then Aiden's videos over with a new title and said trying to destroy Colin's life, to suggest that was some type of intimidation, even though I disagree with that being intimidation. But apparently the Commonwealth then went to the grand jury, presented these titles as intimidation, the titles that would indicate that the whole show therefore was based on intimidation because of titles, which I don't think you can do, but that's what they did. And then of course all this is apparently lost. All right, you can't find the videos. There's no attachment to what the grand jury had. So you don't know what the grand jury had because you seem to have misplaced them, lost them, or you could tell. And he said, well, Tully wouldn't have found them online. But if Tully found them online, he didn't find them online with the title that Aiden had presented. And that is exculpatory evidence. Not only is that exculpatory evidence, that's lying before a grand jury. That's presenting false evidence before a grand jury. That, in my opinion, could easily be a crime. That, in my opinion, can be a civil rights violation, because once you go beyond what you are supposed to do as a prosecutor, you don't have immunity anymore under the law, okay? The individual no longer has immunity. You only have immunity for your duties as a prosecutor and all. So therefore, you've got some very big issues here. And all Brado's been trying to get is the same discovery he has been trying to get since last June, all right? Now, under the new rules, he still can't get the discovery. The judge kind of blew him off. You know, what else you got, Mr. Brado? Because we here went with Cosgrove talking about these, the video at the restaurants and the rallies. We provided that to them. If they can't open them, they were supposed to come to my office and look at them, right? All right. So, yeah, this is this whole hearing actually surprised me how the judge was handling this today. Joanna, wow. It's been a lovely ride for 6 months. Not so lovely for obviously not so very lovely for Aiden Carney, right? He has been delayed. He has been denied. He has been attacked and all. I think I should go buy those rubber duckies. So Bradel said, okay, I will go to the office. Okay. And I will look, I will look at these. I'll go to the office and I will look at what you now say you have, which are these videos. Okay. And then the judge tried to dismiss it at that. Okay, we're done now? No. What Bradel wants, there was emails that they had compiled that apparently also issues with regard to, remember, this is all about witness intimidation in a broad category, different aspects. And he wants not only emails, he wants the metadata behind the emails. In other words, like if I'm in federal court right now, if I just give emails, let me tell you where I've been. The judge is going to say, excuse me, where is the metadata behind the emails? Because you have to, as an attorney, preserve the metadata, okay, behind the emails, for instance, in federal court. Because as we all know, the metadata is where the information is as to where it was set, what was happening. And when you change it and put it on a jump drive and all, you can change the metadata. All right. So he wants the digital editions of the emails to see exactly when they were written, when they were sent to the Commonwealth. And the judge is like, well, you're going to have the emails. He said, no, it's not just about the emails. And I even wrote down here earlier before, because that happened later on. It's about the metadata, right? It's about the metadata. And we even know that for Karen Reed's case. All right. So that was with regard to there. And then the judge is like, what about this government agent? And so Bradel explains that this regards Catherine Peter, who used to work for Aiden Carney, but that she is now becoming cahoots, for lack of a better word. And there's some indication, of course, obviously they want to know whether or not she's been paid out of any snitch fund, I'm going to call it, or in any way, or has gotten any favors, that she is providing information to the Commonwealth on which some of these charges are based, okay? And then this is the judge is like, well, yeah, like, well, so basically, so what? I mean, that's really what I got. He's like, so what? Can we move on? Can we move on? I've got other cases here that we have to get through here. And then Bradel says, look, there's 4,000 pages that were released to the news media. And the judge says to Cosgrove, instead of saying, Cosgrove, did you get them? Did you have them when they were released? Did you send them right over? Did you tell Mr. Bradel to come over and get them with the metadata and all that type of stuff, right? Did you say that to get that over with the metadata? Cosgrove said, well, I was just made aware of it. For how much money an hour are you getting a Cosgrove? What do you mean? You were just in the office 2 weeks ago, and therefore your job is to just sit there? Your job was to go out and gather the specific requests for discovery that have been asked for since June of last year. When we do discovery requests, number 1, number 2, number 3, number 4, number 5, okay, and all. And apparently, oh, okay, well, I just provided that, okay? But again, there may not be attachments to what was provided. There may not be metadata to what's provided. And what's also was interesting to me is Tully going out there and supposedly clicking online. He's got his hand in everything. So then Bradel says, the judge said, well, maybe we'll do this before an evidentiary hearing, and then the backs down, because then Bradel says, I'm taking you up on that, Your Honor. I want an evidential hearing, and I would too. I want to call Peters. I want to call Tully. I want to call Melo, okay, who's no longer the prosecutor, who may not be immune if he presented false evidence to the grand jury, or if there's false representations being made to this court too. That's not protected by anything. There's no immunities for that, right? And then Bradel keeps pushing for that, but then the judge backs down. He backs down with regard to that. And Bradel says it's not just a matter of of what you provide. It's a matter that we want exculpatory evidence. And I wrote down hashtag because it's false evidence. If presented to the grand jury, it's not merely that it could be exculpatory, it could be false evidence. So it's exculpatory plus it's false evidence. It may give Aiden Carney some type of action if you presented something to the grand jury. And so the judge clearly backed down on that. Then there's emails with regard to links. And every time the judge gets to a hard issue where Bradle keeps pushing, he says, well, I'll take that under advisement. Well, can you just give Mr. Cosgrove a list of the links that you're looking for? Well, no, you, Cosgrove, he's already said everything, discovered everything before the grand jury. And now apparently Bradle has to now recreate their discovery request to give a bunch of the links. And the judge says, I will take that under advisement too. Okay. And then there became the issue of whether or not there is a protective order on certain emails that apparently Aiden has seen and Bradle has seen that are still being protected. They're still sealed for the public not to see. And Cosgrove says something to the effect, well, we don't know what interest the public has with seeing an email, and he did some innocuous email. But that's not the issue. All of this should be released. It's not up to the state to say what's of the public interest. It's all of the public interest. You really start needing here, right? Quite frankly, you need citizens groups to go into federal court here, like we did. My Michel Bryant did with getting an attorney with regard to First Amendment, who was just regard to with the buffer zone. You need a specialist to go into federal court there in Massachusetts and to say, this needs to be released. Now, the media is doing FOIA requests, but, you know, budgets are tight and they don't like to hire lawyers. But what he's saying is that, no, the public doesn't have any need to know with regard to whatever these protected emails are. Protected by what? For whom? Why? Okay? The Karen Reed case is over. The Aiden Carney case is still indicted, and it involves the issues of the First Amendment and journalistic privilege and malfeasance and misfeasance and again, possible misrepresentations, and I'll use that word instead of lying, misrepresentations to the grand jury. No, let me go back to the first word, lying to the grand jury, okay? Let me go back to that, because if you're changing, if I write you a letter, okay, and then you get a letter and then you change the words in my letter and you submit it to an investigator and say, look, this is what Linda Kenny Bodden wrote me, and look at her, she's threatening my life, but I didn't put that in the letter, and then I, as a prosecutor, I don't investigate that. I don't go back to you and get your metadata. I don't get a warrant to see what you actually wrote, and I present that to a grand jury. That is just ridiculous. So what they're saying, I guess, is that, well, Tully, Lieutenant Tully, again, who's got his fingers and everything, but seems to have escaped the cross-examination, apparently went back to look at the shows. And then Cosgrove does something really disgusting, in my opinion. He says, I just want to show you that this is continuing. Here's something that happened last night. So we're going to go back and all watch Aiden's last show, right? And you see, here's a little synopsis of what he said. So this is continuing. What it is they don't like Aiden being on them, right? They don't like him being on them. And he's got a right to be on them. He's got a right to be on them. And why? Because he's trying to shine some sunshine into what is going on in Norfolk County. He's the one who brought us, he brought us the whole Karen Reed, the whole problem. Healthy and Happy Kids is a new member. I hope you're enjoying us because you're kind of in the middle of one of my mini rants here because I'm so annoyed with this judge not stepping up to the plate. Nancy New 12, thank you for the donation. Walsh, King, and could get their charges dropped quicker than Aiden at this point. You are absolutely right, okay? At least they have a judge there that's going in the Walsh case that we all believe Walsh is guilty. I mean, to me, the hacksaw and the tooth kind of in the rug kind of does it. But, you know, he does have right now, he is presumed innocent. But you're absolutely right. Lieutenant Pez Dispenser Tully, Linda, thank you. I was infuriated. I don't know where to go, but with your excellent responses, I can relax a bit. It's just crazy making this judge afraid of the DA. It just won't come down on him. just won't come down on him. Even Tubi, you hear Tubi the poodle? Yes, Tubi must know that I'm wearing him. Okay, today, even Tubi the poodle. It's just ridiculous because you're sitting there. You've been asking for discovery. Not only can't you get discovery, you're getting stonewalled by a judge who won't make a decision. And I really had high hopes for this judge for some of his decisions, especially after he had he asked Cosgrove to do that memo. But we've got some real issues here. And you know what? The only thing that the reason why Karen Reed ended the way it was, just so you remember, is because the feds got involved. They were able to get a warrant for the private phones, okay, of Proctor. And if he then didn't have that warrant for the private phones of Proctor, we would have never seen all those emails back and forth. They would never have gone to Jen McCabe. They would never have gone to Kelly. What was her name? Kelly, come on, everybody. You know how soon we forget. They would never have gone to Kelly and all. What was her name? You know, Kelly, I didn't lie to the grand jury. I just didn't understand the question. Come on, you can all remember and all. But I'm disgusted with it. I'm disgusted with justice here. Not Dever. Dever was that was don't call me Dever, right? That was yeah. But everything that is going on, Karen Reed's good friend, who testified for the grand jury. Not Beaver. That's Deborah Kelly Beaver. Oh, that's so funny. This is all going on, and this judge, and Michel Bryant is right. The judge won't hold the prosecution feet to the fire, and this is where I would get in trouble because I would Kerry Roberts. Thank you very much, Pixie's girl, Kerry Roberts. Right? All right. I mean, you've got to hold the prosecution's feet to the fire. The defense is the one on trial. The defense is the one who can go for jail for 100 years. All right. And I have said to judges and it's and I've been called to benches, why don't you just come down here and stand with the prosecution if you're going to make those rulings? And maybe Bradel and maybe Betterow has to do that and get sanctioned and pay held in contempt, because unless you're willing to, like Brian Steele, go to bat to go to jail for that kind of thing, because that's what's going on. The judges are the problem. And I will repeat again, for every single wrongful conviction, for every single person that almost went to the death penalty, that may be 3 steps before the death penalty, there was a judge in the courtroom who did the wrong thing. And this judge, in my opinion, I'm sorry, Judge, in my opinion, I'm doing this as a journalist now, not as a lawyer, because I can't do it as a lawyer, because as a lawyer, I'm not allowed to badmouth judges, but as a journalist, I am. And I'm a journalist for Justice Served TV. I think this is absolutely wrong, okay? This is absolutely wrong. You have to hold the feet to the fire of the Commonwealth. And maybe you're thinking that this is just going to go away. Maybe that's what you're thinking, that if I don't have to deal with it, it's just going to go away, okay? All right? But it's not just going to go away, because they've got their kahunas, their sneakers, their cojones, their balls, all right, and everything else on their effing bodies, excuse me, Skyhopper, close your ears, you're 16, going after Aiden Carney. And it is simply wrong. It is simply wrong. And who's going to help Aiden the way Aiden helped Karen Reed? If it's not for all of you, and if it's not for us trying to help him, no one is going to be able to do that, because the feds aren't coming in for an Aiden Carney, right? They're not coming in for an Aiden Carney. And don't you know that when he is being questioned by Auntie Deb, Jimmy, who's going to be on our show later at 6 o'clock tonight, at his venue, that tickets just went on sale today, but only right internally, they're going to be following every single thing he does. And I'm wondering whether they still have taps on his phone. I'm wondering whether they have, people that go up to want to talk to him in our wire. I'm wondering all of it. Yes, it's at the Wilbur, I guess. It looks like a really pretty nice venue. I see that a lot of the VIP tickets were, half of them were already sold out. But I'm wondering whether they're doing that, because if they're willing to withhold discovery like this, if they're willing to continue to go after him, why? Because they didn't get Karen Reed, okay? So there was always a question. Remember, the question early on was, if Karen Reed is acquitted, will they just drop these charges against Aiden Carney? No. What has happened is because Karen Reed was acquitted, they hate Aiden Carney, whoever they are, okay? And they're not going to drop any charges against him unless they're made to drop charges against him. And quite frankly, if you're the federal government and you're still looking at this, all right, maybe you should look at this some more, because these are the same people that are still responsible for other cases that we know about, not the ones who could get dismissed that we think are guilty, like Walsh, right? Not these cases, but how about Sandra Birchmore, right? They're still the ones. Morrissey's office now. He, of course, this is a special prosecutor, Cosgrove, okay? Still maintaining that her death is a suicide. And again, I disclose, as I disclose every time I mention Birchmore, it was my husband, Dr. Michael Bodden, who for the civil attorney said, hey, look, this is not a suicide. This is a homicide. The feds came in, hired their own pathologist, and agreed, and then indicted Matthew Farwell. I mentioned that only because I have to mention that for people that haven't been in our chat before and haven't discussed this with us. But this is simply, not only is it madness, it really is a really bad look for the justice system, because it's not the justice system. There's nothing just about it. It's completely ice cold. We might as well just take an ice cold bath and put the Constitution in it and let it freeze itself away and go away. Because how can you do a motion and compel? You can't get a hearing. You can't get the documents. You can't get a motion to compel. All you get is things are under advisement. And even when you get them under advisement and some things are turned over, judges stick with judges. Cosgrove was a prosecutor. He was a judge. Power, in my opinion, sticks with power. They don't think Aiden has any power, and therefore that is what's going on here. The power rests with the people that are elected or are appointed or spend the money. The power supports the power, and the power is not supporting Aiden. So we, us, even if you don't like some of Aiden's language, okay, as a woman, I don't like some of his language. I may not like some of his political views, but I'm going to defend his right to say them, because he is a journalist. And without Aiden Carney, who, by the way, when he's on our show with Michel Bryant and I, he is very low-key, very gentleman, because he knows who we are. Probably a lot better than I am when I'm even talking to you, because I, as an attorney who's been an attorney, who loved the law, loved being an attorney, loved doing court work, and all, gets so annoyed, gets so upset that when things are wrong, and this is simply wrong in my opinion. Let's go back. I see a lot of questionings happening here, and all. So yes, you can see we're all pretty infuriated here, and all. But this is wrong. You need someone like, look at Ashley Merchant, right? She went after Fannie Willis and kept going after years, but wouldn't stop, and finally got something to happen, even though Fannie is still the attorney down there. Doug Weinstein kept to his guns with Yak Gotti that he didn't do anything wrong. Now, poor Doug is another case that we talked about today, and that we'll talk about a little bit tomorrow and probably have him on. But he's done the great job as being a lawyer that he can. I mean, and you have to do a good job being a lawyer. Crystal, thank you so much for that donation. Really appreciate it. Joey Kane, what would we do without you? It's Michael. Michael's probably out there looking for his bun right now, right? His cinnamon bun. Another Joey Kane, and another Joey Kane as usual. Okay, and all. But I do want to think more about how we as the public can go about getting this before the federal courts in some way, because it's simply wrong. And maybe it is the U.S. attorney, maybe it is whatever it is, the AG, if there is improper information. The problem is we need to have the documents that showed the grand jury was presented the false titles. We need that. Not just the testimony. We need that. And maybe some of that is in the impounded discovery that we don't have access to, and that Aiden and his attorneys can't release, because then they will go to jail for violating a court order. How ironic. Now, I did hear a beep in my ear, And I think that means that Michel Bryant is out of court, because I will tell him he hasn't been able to hear me, but I will tell him that I have been incensed, outraged, pretty annoyed about the lying before the grand jury, the ineffectualness and the lack of balls of the court, quite frankly. And I'm going to say that in doing anything. And you said it was going to happen. All right. And I had great hopes about this hearing. I had great hopes. I think Tim Bradel did a remarkable job. But when the judge says, okay, let's have an evidentiary hearing, and Tim Bradel says, do it, let's do it. And then we don't get it. We don't get it. Why? You're not going to get it because Cosgrove just makes representation and then goes after Aiden with something that he said on his show last night.
I just
I'm
finished.
Beyond.
Can you hear me? I can't remember.
Yes, I'm sorry.
I just finished a long courthouse steps interview with Bradel and Aidan, and those were the things we talked about. The first thing I said was, it is very lucky I don't practice here because my ass would be in jail.
Well, I said that as a lawyer. I'm saying these things as a journalist because I can't say them as a lawyer because I'm an officer of the court.
Well,
but as a journalist, I'm saying, get your fucking sneakers, Judge, and make the prosecution be a prosecution.
I said the problem is, and Bradel is in a position. That's why I said I don't practice here, so I can do this. And yes, I'm an officer of the court. There's a big risk.
But you're a journalist right now. We're not talking as officers of the court. We're talking as journalists.
I just said with the way the Commonwealth is dicking around with this material, and then the court does nothing to hold their feet to the fire. That's the problem. And they will continue to dick around until the court does something about it. And so far, they have done nothing. Now, of course, Bradel and Aiden, to the degree that he can restrain himself, has to say, Doolin is trying. No, he's not fucking trying. He's not doing anything. He's allowing Cosgrove to do exactly what I predicted from last night. They dumped those documents on these guys 10 o'clock or so last night. Sits in the courtroom today and says, well, we've complied. And what's the court say? Oh, well, you got it. All right. What's next? What's next on the list?
Michael, your microphone went. We can't hear you. It's all you're like there's air.
Oh, I know why. Hold on. We've got the wrong input here. Sorry, it was setting it up quickly. Let me fix that. I apologize for that annoyance. Stand by.
It's like there's a hurricane coming through your microphone.
And it's actually not that bad. So here we go. Let me fix this. There we go.
I'd like
How's
to see all the discovery. This is what I'm unclear. Is Bradel and Bradel prohibited from releasing all the discovery they already have, except for the protected stuff, to the public? Are they prohibited from that?
There's no protective order or impoundment. Can you hear me now? Is this microphone working now?
Right.
Okay.
Right.
Unless it's specifically impounded or, as they're calling it, protected. I mean, it's a distinction without a difference. And so the court was asking about that. What are you wasting time talking about that for? We know what impoundment and protective order mean. It's virtually the same issue. So the answer to your question, no. If it's not specifically impounded, then no, they can do what they want with it. The key issue here is that all of those FOIA documents that were released from the DA's office, Morrissey's office, that everybody on the planet has if they want them, to hear Cosgrove and the court say, no, not those. I mean, they do have some redaction in it, but there's a lot of good stuff in there, as people have been reading. But to have the court and Cosgrove say, oh, hey, never didn't see those, haven't heard about that. That's so unbelievable. It's got to be a lie, or they're that stupid. I can't imagine. How do you have Cosgrove giving program, time, title, and a time code for things he's alleging Aiden Carney has said? He said not violating any of the orders against him now, but still, Judge, you need to see this stuff so you can see the tone of these shows. How does he know that minutia, but not know the worldwide release of all the documents that they now are trying to continue to protect?
What does the tone of the shows have to do with anything?
Nothing. And that's why
indictment for specific items. What is the tone of the show? Our show has a tone too. What does that have to do with anything?
It's just moronic that the court will allow kind of counter argument. And so now, as it stands now, because the court, none of these judges here have the balls to rule from the bench.
Right.
None of them.
They
take everything, taking it under advisement. Let me take that under advisement. Well, screw your advisement. Have some guts and say what you're going to say down the road. You already know. There's nothing that's going to change your opinion. So what the judge says, of course, is I'm going to take that under advisement regarding, get this, Aiden's ability to use the documents that everybody else on the planet can use if they want. I've got a bunch of them queued up here right now. I could use them anytime I want. Aiden Carney can't use them because they're the same documents under the current impound order.
How do we know they're the same document?
Well, in theory, and that's a good question, because Cosgrove volunteered to go through the 4,700 documents one at a time. I'm being bombed. Scott is back.
Hey, Scott.
Before I leave, say hi.
Hi, Linda.
Hey, Scott.
So
hey,
I'm
your sign. Show your sign.
Oh,
Come on.
show,
Come on.
show, can you see? Here, I'll get out of the way. You can see the sign there.
There you go.
Okay.
Thanks, Scott.
So I okay, take care, man.
Hey, nice commentary, Linda.
Thank you.
Nice comment. Did you hear that? Nice commentary.
Yeah, because I don't hold back, because we know, look, I practice in federal judges. Everyone knows that I'm a fire-breathing dragon, okay?
Yeah.
I mean, that's what it comes down to, and you better be that at this point.
Well, yeah, when you see this kind of stuff continue to unfold, it's just an embarrassment for the profession. It's embarrassment for the judges. So Cosgrove volunteered, hey, let's just go through those documents one at a time, the FOIA documents and those that you believe should not be any longer protected. And if we find those that are in common, then sure, why don't you do that? What, you think that's going to happen? There's not a chance in hell that's going to happen. Nobody's going to sit down and spend hours going through the 4,000 plus documents one at a time. Yeah, that one's good. Nope, not that one. That one's okay. No, not that one. It's not happening. And the court shouldn't even care. The court should say they're no longer protected. What's the protection for? And I asked this question last time I was up here. Who is the court protecting by failing to release these materials?
Power.
We know it's Proctor, it's Tully, it's Morrissey. Yeah, well,
Melo.
Morrissey's outed. Well, Melo's
Melo.
and that's a whole nother story. And they're continuing their effort to get him removed from the case. Remember, they want him as a witness because Kate Peter. Here's the trifecta of terror: Kate Peters, the prosecution, and Melo.
Miss New Couch.
Kate Peters. Is it Peter? It's singular Peter. She has only one Peter. That's what I'm getting at. Okay, so those folks were sharing information. Kate Peter becomes an agent for the government, and Melo's in that triangle of communications. But he's still got his fingers in this case, which prevents him or makes it less likely he can be a witness. The defense wants him as a witness so they can talk about the K. Peter shenanigans, not just changing the title of some of the clips, which was bad enough and blatant enough.
Pretty hard. I mean, if that's
of course it is.
Grand jury, that's lying to the grand jury.
Of course it is. So there's much more that she's done. So they need to break through that triumvirate and get Melo out of that protected role so they can bring him as a witness. Will there be an evidentiary ruling? I would bet every penny that I have in the Justice Serve TV bank account that they are not
very much.
Come on, at least we could play it up. That they're not going to get an evidentiary hearing to call K. Peter and Melo to the stand to talk about their relationship. It ain't going to happen. And I'd love to be wrong.
The thing about it is if you step out, the Supreme Court case law on this, I know this very well because if you're because depending on suing, for instance, if I as a prosecutor, I go and I do an interview, okay, outside getting somebody ready for the grand jury, but I go outside with my cops and I do an interview and I do something bad. I don't have qualified immunity for that anymore because I have stepped out of my bounds of being a prosecutor. I now have become an investigator. Okay. And that's really where they need to go. Did Melo step out of his bounds becoming a prosecutor? If he knew that the titles were wrong, did he step out of his bounds? Now that still may be protected because there's some really bad Supreme Court case law that you could actually, commit a crime as a prosecutor if you're doing it within the bounds of your duties. You have absolute immunity, but you got to find out. You got to find out what the facts are.
And before you even get to that, you have to pierce this alleged protection that he has as an attorney of record. He's technically an attorney of record still.
Right. So now
get him out of that role, and then you can start digging into what he did know, what he didn't know, what he condoned, what he did not condone. I mean,
but
it's
whoever it is, if somebody, you now have prosecutors prosecuting a case that they may have known that false evidence was presented to the grand jury. And I don't care if you change the titles of these things to show intent, because my view is that this statute is unconstitutional, right? Because it focuses on, I didn't feel good, instead of the intent of the person making allegedly trying to put fear into God, right? About testifying. I'll kill you if you testify. That's the standard, right? Note that
that motive to create intimidation is so central to the argument. So if the grand jury is hearing a title that is manipulated from Colin Albert continues to lie to how I'm going to take down Colin Albert. I mean, that's a huge difference.
Ruining Colin Albert's life about versus why is the Commonwealth hiding Proctor? I mean, it's worse than that.
Oh yeah, it takes it from kind of a creative title to something that sounds like I'm going after this guy, either physically, financially. I'm going to ruin him, and that's the crux of the charge, whether you believe in the statute or not. That's the crux of it. And the grand jury's hearing what Kate Peter and through her, the Commonwealth, want this grand jury to know. Otherwise, how do they hand down indictments? Do they hand down indictments? That's the real basic question. Do they hand down indictments if the original titles were used?
Right. Cusco Wright says Aiden's calling into Melody Stream, but Michael's got the interview with Aiden, which we will play at 6 o'clock tonight when Jimmy, Auntie Deb is going to be on. Remember, Jimmy has the Wilbur interview where tickets are on sale for if you have codes right now today. He's got the Wilbert interview of Aiden on September 12th. And my question is, are they planning undercover offices? Are they buying tickets? Are they planning undercover offices there? Do they have wiretaps on them right now? Because when Cosgrove went up, Michael, you were there, okay? Went up and said, I just want to show you, Judge, how this is continuing. This is from his show last night. Let me just show you.
And you know what it is, right?
What was it?
Aiden flashed it in during our interview. You'll see it. Anybody that has followed any of his stuff, even just peripherally, he does a thing that's sort of like March Madness, okay? But he calls it Ratchet Madness, and he pits characters from this trial and the extension of this trial against one another, as if it's like an NC2A ladder, right? Cosgrove is actually in the mix. He is one of the players. So he brings the ladder, during March Madness, everybody's got their ladder.
Yeah,
he basically has that, but it's a little more elaborate. It's like bracketology, but not quite, because it has like a picture of the person and a little blurb about them. Picture of the person, little blurb, and they're seated. And Aiden said that as Cosgrove was leaving the courtroom, and to him it's just another payday, it's all a joke. And with Doolin, I feel the same way about him sometimes. He laughs way too inappropriately, as if this is nothing. But Cosgrove's coming out, and he basically tells Aiden that he has told all people to vote for him. So he's playing along with the game.
Did you say that again?
That wasn't publicized, but it was something Cosgrove did as he was leaving the courtroom.
That's what I want to hear. You hear to say it
and
again.
He basically, after telling the judge how outrageous that is, and you could just see the tone of what this man is willing to do. This is not a violation. We're not saying that it's an act, a criminal act, but just look at this, Judge. You can see what it's all about. And the judge looked at it, and then he just kind of sort of laughs at it, really. And then as they're leaving, Cosgrove brings it up again, but in the context of, hey, I'm asking everybody to vote for me.
I was hitting my head like this a couple times, okay? Because I was like, no, because I was like, I don't want to get CT, I know. But I was like, I can't believe what was happening. But when you're telling me they're making this a campaign thing, coming out of the courtroom for him, I mean, what are we talking about here?
Yeah, you can't really make fun of that whole shtick, and it's a clever shtick. I get it, the ratchet madness. But if you're part of it and you're promoting it, it's so just don't be that kind of dick. Just leave it alone. Don't just leave it alone. But no, he has to make a big deal out of it and go to the judge and hope that it gives him some favor with the judge.
Yes. By the way, Michael is live at court. He was in court. He's standing. This is, I think, I thought it could be your 19th trip up there. I thought it was 18th, but it could be your 19th trip up there. Yes. So we have been staying with this case. We were there before the Karen Reed case started, and we've been staying with it, and that's how we met it. But yes,
I've seen most of the seasons. I think February was the first trip up, and that was cold as.
I know you have been cold. You've been under the rain. You've been hot. We had to buy a tent.
I'll take this. I'll take today. Yeah. It's a little breezy, but it's fine.
But really, because this is so darn important, because this really involves the whole issue of who is a journalist. This involves the whole issue of the First Amendment. And there was a whole thing initially about, well, if Karen Reed were not convicted, wouldn't this Aiden Carney thing go away? And it should. But not only is it not going away,
they doubled down.
It doubled down. They're doubling down on it.
I think what I suggested in one of our posts was that now they've moved the bullseye from Karen Reed to Aiden Carney. Like they need a victory, anything. I need something, because they look so ridiculous. But they're so out of touch and so tone deaf as to what this looks like to the normal person that they don't get it. They just don't get it. And I don't think, to all due respect to all judges, the judges in this case, including Doolin, are doing nobody any favors. Regular folks are seeing this and saying, how can the judge allow the Commonwealth to act like they do and just ignore all the rules? How does that happen?
That's right. That's every single question we have. That's exactly how it's happened. I mean, I want to come up with my ducks. Do you think if I wore a duck hat in court that I could be arrested?
You could.
Right?
Well, no hats in court. Sorry, no hats.
Okay, I'm sorry. How about if I put it on my clothes? How about if I
You could probably get away with that.
Jacket?
I've seen some interesting outfits. You could get away with that. For Q-Bert, I talked to Aiden and Tim outside on the courthouse stuff. We went for about 10 minutes. It was almost a one-on-one because I was asking most of the questions. But we'll post that soon enough, and we're going to be back here at 6 to kind of go through this.
So are you going to post that before we get on our show?
Well, let's see. That's an editorial decision. What do you suggest?
I think we should post it before our show and then play it during our show also.
Okay.
I think we should
play it.
Like some people
can't,
some people have kids and dinner and it's hard.
Hey, I forgot to ask, because I've been in this circus, has Nicholas Casotis been convicted yet? Did that happen while I was gone?
I don't know. All I know is Doug rested. I don't know. Does anyone know whether or not Doug had any redirect questions of Casotis? But I don't, Casotis, I was upset for Doug. I felt bad for him because he really did a nice job doing Casotis's case for him.
He really
did.
And
then we saw last night starting to lose control, and today you can't even make it up. I mean, you can't make up who knows? Somehow this guy who worked at JAG, and if he did work at JAG, I don't know, for 10 years, and he's a lawyer and has all these degrees. Somehow
he's got the LLM now and blah, blah, blah.
Worried about people after him and had to move 150 times in 5 years, and with pins and bins, and his wife was pregnant, but she wasn't pregnant, and she was pregnant, she wasn't pregnant.
Right.
And
well,
then
his
father was in court. But,
I'm not trying to chase people over there, but Diz said they're doing closing arguments right now.
They are doing closing. I'm shocked. I thought they would do it tomorrow. I think Doug was like, let me get out of here.
Can you get a verdict by 5? I could save a night in the Savannah Hotel. And for those who saw the interview I did with him Friday, he's in the JW Marriott. And I tried to tell folks what that means.
Great Marriott. Yes,
versus,
I know,
there's the Marriott, then there's the Marriott, then there's the Marriott, and then there's the JW Marriott.
Yeah,
it's an amazing hotel in Savannah.
When we were staying out in northwestern New Jersey near Burnsville, we were actually it wasn't near Burnsville. We were in a JW Marriott for 6 months doing the Jason Williams case. And it really was a nice hotel. Then I had to stay at a regular Marriott.
It is.
I was a wonderful hotel.
I told a little bit about my story when I stayed in Caracas, Venezuela, on the way to doing my undercover story at the whorehouse on the island of Santa Margarita.
You got to hear that.
Best hotel ever. And they told us, don't leave the hotel. In Caracas, not exactly.
Was it being used? Was it being used for the story that you were talking about?
No, it was not. That was a way station on the way to the Pleasure Island. Yeah.
All right. So anyhow, so tomorrow night, by the way, we're getting ahead of it, but tomorrow night we plan to concentrate on looking at some of the cross-examination and obviously the closings that we didn't see, and maybe we can get Doug on by then, because that jury is going to have a verdict. I don't know. I mean, if I were a betting woman, which I'm not because I only play poker, okay,
and that's a game of skill, not chance. Is that right?
That's right. That's right. That's what many of the courts have ruled. And there really is a lot of skill to poker as opposed to just chance, because you got to know when to raise, you got to know who evaluate. There's a lot of skill involved. And there's luck too, because the cards rule. But whatever it is, I really want to. Poor Doug is probably like, be nice to me. We're really nice to him because we've all been in that position. I think this is an assigned client that he has, and all, because he's been.
Yeah, that's interesting. I don't know. I mean, because it's clearly a distance from Fulton County, where it would be natural for him to be on the list. But I guess if he's on, maybe it's a statewide list they do there. I don't know. I'd like to know more about that. But I do believe, yes, he's being paid by the taxpayers for.
And the jury's instructions will be tomorrow. So the question will be, will the jury decide to have lunch together? Probably, yes. Because and then they'll come out right after lunch. That would be my.
That's
guess.
My thinking. Sometimes it depends on how good the lunch is. We come to a decision, and they're like, let's go through lunch. Kind of think about this. What's on the menu? Hot dogs? Okay, forget it. We're ready.
Yeah, but they have to. But there's a lot of different charges that they have
That's
to
the
go
key.
through.
There
That's the key.
are
There's a lot of different
13
charges.
counts.
Right. So it's not. It's gonna. It could take the whole day, but they're gonna be done by tomorrow. They're not. That jury's not staying one more extra day. They're not gonna think about it. I mean, till Friday.
I would agree.
Unless somebody wants to take Friday off, and there's a whole jury psychology because people, if they get to Friday, then they don't have to work. So sometimes they come over, they stay, they go home, they come back, they announce the verdict in the morning because then they have the whole day off and they don't have to go back to work. So that could happen.
It could happen. Yeah, I don't know enough about how much they get paid in Liberty County. If it's $35 or plus mileage.
Just having a day off, Michael, has nothing to do with the money.
Well, every little bit helps. We're not all independently wealthy. That $35 will pay for something. So we'll see. We'll see what they're motivated by.
We'll see. But I can actually, those are the jurors that I would love to interview because, and I also felt bad for his father. I have to tell you the one thing.
I can't imagine being the parents sitting there
listening to their son who's saying that he's no longer her son, that he's discovered he's somebody else, he's a Sark. Clearly, there's something really wrong, okay? And I said,
no doubt.
As you know, that I said a number of times that I thought, and I've seen this done, I've seen judges ask for an independent court review of somebody who clearly is a nut job before they get on the stand to see whether or not they can voluntarily make the decision of whether they should testify. And I've seen that happen, and obviously they don't want to spend the money on him. But if there was ever a case that deserved it, it was that. And again, I don't understand how women get so attracted to him. He had the first wife,
that's
wife,
always
and the third wife.
I'm sure folks remember the Thomas Randolph case.
Oh yeah, 6 wives, right?
Yeah, and a lot of them died under very weird circumstances. I think 3 out of the 6, or a lot of them. And if you see the guy, it makes you just ask that same question: how does this doofus, wrangle all of these women?
Right.
It's amazing. But this guy's done the same thing. And after hearing him talk for almost 4 hours, I'm not getting it. I don't see the charm. I just don't get it.
I don't see this. So we'll be doing that tomorrow night, and maybe there'll be some left over on this. But tonight we do have Jimmy at 6. We're gonna.
Yep.
So you're gonna try to rack that interview with Aiden and all. We'll try to get it out there. If you hit subscribe, like, share, notify, when that goes up, you will get a notification. And then we'll also probably play it during our show. I think Jimmy's planning to be with us for about a half hour because he's taking care of his nephew. Which maybe we will see or will not see. I mean, I really want to know whether there's some constraints. They feel constrained because with everything that was going on in the feed, and as you all know, I've been busy with my cases, and I will be busy with my cases for the next couple of weeks. But somebody who he's fighting with was trying to get his show canceled at the Wilbert, saying that Aidan was an anti-Semite. And so you have that going on behind this. What a mess! All I can say is what a mess. But I wonder whether there be undercover agents there.
I would be surprised if there are not.
Right, I agree with you.
Why shouldn't the taxpayers pay for tickets to the show? Why not? They're paying for everything else. Let me look at my list here. Let me confirm first of all. Did you have just audio?
No, we had video.
Good.
Yeah,
Then let me see.
But it was mostly the judge. It wasn't of the attorneys.
I noticed the cameraman shooting that, and it seemed like he was pivoting every now and then between a shot of the attorneys / Aiden and the court. But you're saying it was most always the court.
Did you see Aiden? I didn't see Aiden once. I didn't see Brado once. I saw
nice
Cosgrove when he walked up to the bench.
Yeah, the seersucker kind of suit on.
But it was on Doolin. The only time you saw Cosgrove, you saw when he went up the bench to give. I just want to show you how this is going on. But you didn't see Aiden or Brado.
Okay, let me give you just a feel for what was going on in the courtroom.
And was Betterow on Zoom?
No. Okay. No. There were some other folks on Zoom popping in inappropriately, because people don't know when they're muting and they're not having conversations having nothing to do with what's going on in court. This was before Aiden Carney's case was called. There were probably 60-ish people in the gallery, and I would suggest this place will hold 80, give or take. So not packed, but plenty. And I'm sure you saw a lot of them out here behind me queuing up before the hearing began, and you'll see them in the video of the interview that I was doing on the courthouse steps. Let's see, any other comments? Oh, when Cosgrove, and I'm not sure how much you hear, but there was that discussion about, do it, have the evidentiary hearing.
Right.
Let's do it. Then there was a sidebar. Okay. So they call the sidebar. I don't know. Did the camera stay on them? Did
No,
it tilt
no.
up? Did it go away? What happened
No,
then?
it just stayed on the empty judge's bench.
With the white noise. Okay. So at that point, Aiden gets up because he's attended most of the sidebars in the most recent hearings. And Cosgrove said, I object to that.
What? You
I
can't object to that. I've been
course he
saying my
can't.
whole career that's an important part of proceeding.
They
and
have
the
that
finest now.
absolute right. And of
Right.
course, the judge said, ignored him. And then they had their little sidebar. Of course, they couldn't talk about what that was, but it was directly related to the conversation about the evidentiary hearing because I'd queue up for that. I'd pay a ticket price to go watch Kathy Peter and Melo and Tully testify about their relationship. Oh man, that would be some good legal theater.
Yep.
Let's see. Anything else that you had questions about because you couldn't see or they weren't showing it or what?
No, that's
Check
about
your
it. I think about it. We talked about it, and I think we talked about a lot of it. Just this whole the judge is kind of like putting it aside. Well, you can go to his office. When you go to his office, we're done now. I have other cases to do.
Yeah, and then there was the issue, which is really a big issue, and that has to do with this intent and Peter changing those titles, right?
That's
And
important.
the judge more than once said, "Well, we're getting off track here."
Right.
No, you're not. You're trying to derail the defense. I'll give you that, but you're not getting off track. That's the guts of some of these discovery issues. You can't just push those aside, But he did a couple of times. He did, and Bradel had to keep kind of circling back to make the court aware. This is not just sidecar stuff. If we're going to continue the train analogy here, this is the locomotive. This is driving this case. The intent you claim my client had that led to those charges.
Right.
Objection. Everything I've marked here under advisement. That's the no balls rule is in effect.
Yeah, and there was the only thing he did. He's directed Bradel to give Cosgrove a list. He directed Bradel to give Cosgrove a list of the videos.
do some busy work for the Commonwealth. Well, you heard what Bradel ultimately said. He said, "A judge, you want a list? It's all of them, So just look at what you sent and know that none of them work."
Right.
None of them.
None of them work. And then the only other thing I want to talk to you about, I want you to think about for tonight, is when Cosgrove says, I don't know what the public interest is in this. And he had one I didn't hear what the email was. He pointed to one specific email. He says, I don't know what the public interest in all this is.
Yeah, let me
and I didn't hear what that email was.
Yeah, I don't know. I think part of the issue was that the defense has been given parts of text and parts of emails, but not the dialogue. And so I think Cosgrove was responding to one of those where the defense got part of it, which said something like, let's get together on this and talk about it when you can. That's all they got. They didn't get anything about what the subject is, what the response is. And I think Cosgrove was just saying these partial conversations really, what's the public interest in that? Well, first of all, that's not the measure. It's not the public interest. Rule 14 is not about the public interest. Rule 14 is about exculpatory and other information the defense has a right to. So public interest is a non-factor. I don't know why
public interest
bring
goes
that
to
up.
the protective order, though.
Yeah, but ultimately,
The
if you get
first
past
issue-
that,
right, the
there's
first
no way
issue.
you can argue the public gives a rat's ass about it. Really,
Right,
I mean,
right.
really, I think it's a non-issue. They're protecting it because they don't want to embarrass the people involved on those various emails and texts. And as Aiden points out in the interview that we're going to post here soon, they meaning the defense, because it was in social media, they would get, I think it was Kate Peter's text string, right? And it would have her text response. The Commonwealth provides just one side of the conversation.
Oh.
So who redacted and took the other side of the conversation out? When here it is, we see it. It's been provided through other channels. That's how blatant they are about breaking the rules and sandbagging. It's outrageous. And once again, judges have to get off their asses and do something, or this is going to continue. Happens to you, happens to me, it happens to anybody here. You got to enforce the rules equally and don't just laugh it off.
Right.
Nobody's laughing, Judge.
No chuckling like the judge was doing as he left the bench. No chuckling.
No, he's a chuckler. Yeah. That's his thing.
So you're going to get that ready.
I'm going to go down to Dedham Pizza. When you're in Dedham, try Dedham Pizza. It's really very good. So I'll go down there and get some Dedham pizza and get that thing posted.
Yeah, and get it posted, and then we will see you all back at
And
6
Jason
o'clock
was here. Some of the other names. Jason was here.
Jason was there, yeah.
And Tom was here.
Okay.
Obviously, Scott was here.
Here, right?
So a lot of the regulars were
Good,
here.
we're here.
You know,
Good.
hoping to find, I don't know, a little smidge of justice.
Yep. Yeah. Just a smidge of justice. So, all right. So we'll see. Also, get a few minutes of rest because I know you drove all morning and then you have to drive back.
I'll tell you, once I have that pizza, I'll be ramped up, ready to roll. Yeah.
All right. Well, we'll see you back at 6. Please hit the subscribe, like, share, and especially that notify button before you go. Let me just say to you that Josh H., thank you very much for being Aidan Walsh King and others. NCDA has serious issues providing discovery in cases. That is true.
It can't stand.
Yeah.
It just cannot stand.
Oh, right. Nancy knew wants Michael Easter to take a look at the data in this case, in Aiden's case. Wouldn't that be great? Ooh.
Be great. That was another sub issue, is that they can't get the metadata for these different pieces of material. And, you know, the judge and Cosgrove both make it sound like metadata. You're speaking a foreign language. I do not understand what you're talking about.
Metadata? What is that?
What is that? You're making words up.
Yeah.
So good luck getting that stuff.
Yeah. All right, all. Again, subscribe, like, share, and then notify. And when Michael posts the Aiden and Bradel interview, you'll get notification of it. We'll also try to play it tonight, and we'll see you at 6 o'clock tonight with Jimmy. We have a full pack show, and I hope I don't lose my law license because I was saying all those things about a journalist. But you know what? You know what? Unless somebody tries to hold their feet to the fire, it's going to continue.
That's right. So, not what happened here today, but please try to do the right thing. We'll see you later.
Ashes on the sky.